persons having business to do before this court will draw near and give their attendance to be heard.
Good morning, everyone. You may be seated. First case on for oral argument is 1424, People v. Stenardo.
Good morning. May it please the court, Bridget Field on behalf of the defendant Anthony Stenardo. Actually, I've raised 3 points, but they really all boil down to the same thing. My client was disabled. I don't believe that on this record that it demonstrates that I believe that there should have been further inquiry into his mental status with regard to whether the plea was knowing and voluntary. In this case, the court had before it a pre-plea investigation which provided significant insight into his limitations and significantly the fact that he had a declining IQ. His IQ was noted at 68 in 2001. It had declined from 94 over the years preceding that, and 2001 was approximately 12 years prior to the entry of the plea in this case.
Okay.
I rest on my brief unless the court has any questions.
Good
morning. Dan Gross on behalf of the people. Any challenge to the sufficiency of the colloquy is unpreserved. And as our brief states, there's no indication that this would fall within a Lopez exception based on the nature of the colloquy. The defendant was able to answer all the questions. Any challenge to an affirmative defense was sufficiently followed up by the judge when she further questioned the defendant. Unless there are any questions, I'll rest on my papers.
Thank you.
Thank you.
1425, People v. Paul. Good morning.
Good morning, Your Honor. May it please the court, Tom Theophilus appearing for the defendant. In this case, we have an antimarchy waiver that took place at the sidebar. The people have the burden of establishing the validity.
You spent quite a bit of time in your brief on that issue, right? That's sort of the major issue in the case?
Yes.
So what, I mean, Flynn is the issue, right?
Flynn is the issue. That's correct. That is the issue. One sense, I just want to mention that the people have the burden of establishing an adequate waiver. My argument is that there are two elements to an adequate waiver here. One, that the lawyers issued the waiver, which the people established. Two, that the defendant was present for the waiver. I argue the people have the burden of establishing that, okay, because under People v. Lucius, the people have the burden of establishing a valid waiver. They're claiming that I have the burden to establish that somehow, so that would mean that they have the burden to establish that the defendant was present at the bench conference at the time that the waiver took place.
But they have the presumption of regularity, as the Flynn court called it, correct?
The presumption of regularity does not apply to their benefit for purposes of determining whether the defendant was present at the sidebar for purposes of the waiver, because when you're dealing with a waiver, the burden is on the people, according to People v. Lucius and several other cases.
Right.
Now,
Lucius was decided a long time ago. Would you agree that the Court of Appeals has held that the lawyer can waive those rights, the sidebar rights, to be present for his client without his client even hearing it? I mean, there has to be some discussion, but under all these cases from the Court of Appeals, Velasquez, Vargas, Flynn, the lawyer can do it outside of the defendant's presence.
that's not correct, if I could be heard on that point, Your Honor.
Sure.
All right. Number one, Velasquez from the Court of Appeals, which predated Flynn, specifically said in that case that the lawyer had to be present. Flynn is distinct.
Lawyer has to be present.
I'm sorry, that the waiver had to be made in the presence of the defendant. That's Velasquez. Flynn had a situation where the lawyer came up to the sidebar, waived antimarchy in the absence of his client. But in that case, the lawyer specifically stated on the record as an officer of the court that he had spoken to his client about the antimarchy rights. So what Flynn said, what the Court of Appeals in Flynn said is, okay, generally the waiver has to be done in the presence of the defendant. But in this case, since the lawyer affirmatively stated that I told my client about the antimarchy rights, Therefore, the Court of Appeals said, under those circumstances, we're not going to require that the waiver be made in the presence of the defendant. The issue, I think, for this court now is looking at that Flynn precedent, where they said, under that factual scenario, that the defendant did not have to be present. Are you going to expand that to say that the defendant doesn't have to be present even in a circumstance where the lawyer does not affirmatively state that
But
he
he's in
told
the
his client?
courtroom. He's in the courtroom.
He's in the courtroom.
Okay. So now we look at Velasquez, where it's waived, Anamarchi waived. That's all we have.
That's right. But that's in
And
the presence of the
defendant's
defendant. Right.
Right, so this case is really no different. So.
Well, no. The defendant did
One
not.
second, sir. And I get why you're going to say that. But what I found significant, my question is, did you find it significant that Judge Robert Smith was in the dissent in Velasquez, but then wrote the majority, if I recall correctly, in Flynn, essentially saying he's folding his tent, as I see it. The presumption of regularity, we can trust the lawyer, period. Don't you read Flynn that way?
No, I don't read that Flynn that way, and I think you also have to look at People versus Jackson, which is from the Court of Appeals that comes after Flynn.
Well, Counsel, let me more pointed question. The court says to the attorney, the record will reflect that the counsel, Mr. Lankowitz, and the other co-counsel have indicated they would wish to waive their client's presence at the bench. Is that correct? The attorney says yes.
Right.
Okay, now you're saying that that colloquy between them is insufficient because he didn't specifically say what they were waiving?
It's insufficient because he didn't say that he had spoken to his client about the antimarchy.
Well, doesn't the Court of Appeals case say that we assume when a lawyer makes these representations to the court that they have spoken to their client? And in fact, there's one of the Court of Appeals cases I was reading this morning directly said that. It said we have to assume that, these are lawyers, they're representing their clients. And we can't assume from this record here that we're saying, so that's insufficient. It would have been more sufficient if the court says, you've indicated that you wish to waive your client's presence and that your client agrees, or you told your client.
Right.
You think you need that extra language?
You need that extra line. Not only that, if you look at the way it's written here, it gives the impression that the lawyers think that this is a right that they exclusively have the right to waive, because there's a lot of rights that lawyers alone can waive without getting the approval of their client. There are other rights that require the approval of their client. Antimarchy is a right that is personal to the client. That goes right back to the antimarchy case itself. And then if you look at the case of People versus Jackson from the Court of Appeals that comes after Flynn, where they were talking about antimarchy, the Court of Appeals goes through a litany of how the judge allocated the defendant in open court with respect to antimarchy to make sure he understood it. And I'm reading this case and I'm going, why are they even going through this? According to Flynn, couldn't they just say, we don't care? The lawyer waived it? Instead, no, the Court of Appeals goes through this litany and then they don't even mention Flynn in the decision. People versus Jackson, which is in my reply brief. All right? And the key here is that the right is a right that is personal to the defendant, and the defendant has a right, has to be informed. The question is the degree to which the record has to reflect whether the defendant has been informed. Velasquez was clear that it was necessary that the waiver be on the record. Okay? Flynn carved out an exception, but under a factual scenario where an officer of the court gets up and says, Judge, I'm telling you as a lawyer, as an officer of the court, I spoke to my client about this. Well, I think that's a different situation. Now you not only have to, now you'd have to presume that the lawyer is lying to the court when he says that he spoke to his client. So I can understand where the Court of Appeals would say, we're not going to presume that the lawyer is perjuring himself in front of a court that he's responsible for arguing in front of. But if you were to take, Judge Central, what you said to its logical conclusion that we're going to presume that the lawyers are going to inform the clients of their rights, you wouldn't have to mention antimarchy at all. The simple fact that the defendant did not come up to the sidebar, you would presume that the lawyers know antimarchy and that therefore they informed it. Under that theory, you don't have to have even a waiver, because the lawyer is presumed to know what the law is.
So you say, did Jackson modify Flynn? Did it?
No, Jackson didn't. I'm just telling you, I'm looking at Jackson, and it's presenting somewhat of a confusing circumstance to me. Jackson said nothing about Flynn. That's what's so confusing about it. And it came recently after Flynn. And it was a case where if, in fact, all you needed was a waiver from the lawyer, then the only thing Jackson would have said was Flynn. According to Flynn, it's fine. And they didn't do that. And Jackson didn't just deal with antimarchy, it dealt with a number of other issues. So clearly, the court didn't need to go into a discussion about how the judge allocated the defendant on the record with respect to antimarchy, and this is a great thing. Why are they even doing that with Flynn? And especially since it's an ancillary issue in the case, it's only one of several issues, they could have just said, antimarchy is an issue here, according to Flynn.
If we follow Flynn, you lose, though.
No, no.
Flynn, the waiver was outside the defendant's hearing. The defendant was not privy to that. It was at the bench. And the defendant, it says right here in the Court of Appeals decision, out of the defendant's hearing, the defense counsel waived his rights. So I want to put one thing on the record. Mr. Flynn's remained at the counsel table. I discussed it with him, and he understands his rights. So it was outside the presence of the defendant. Mm-hmm. You're saying the defendant has to be part of that discussion.
No, I'm saying the defendant has to be, I'm saying that the defendant has to be present for the waiver when the lawyer does not affirmatively state on the record that he has informed his clients of his antimarchy rights. And here, where the record seems to indicate that the lawyers view the right.
I see with Counsel, we understand your argument. Where I'm a little lost here is that what we're saying, though, at the end of the day, is that what the lawyer said here was insufficient. Your argument,
right?
And I'm thinking to myself that as a judge, all of us here, prior trial judges, and a lawyer makes a representation to the court, okay, that they're waiving it, that you're just saying that they can do it. I'm not saying you can't,
right.
But the language wasn't
That's
there.
correct.
And without that language, we don't know whether or not he informed his client.
Right. The lawyer has to say, I inform the client. That is the distinction.
We got that.
If he says that, then yeah, you're right. It's waived according to
So
Flynn.
really, that's
If he said instead of just saying antimarchy waived, if he said my client is waiving his antimarchy, is waiving his right to be present, would that be enough?
It probably would, because he's now saying that my client.
Instead of saying I told my client and he waives, if he's saying my client has agreed to waive.
That would make it better for the prosecutor. Here, it's almost the opposite. They're implying that
The lawyers
the
doing
lawyers
the
are
waiving.
waiving the right. You see what I'm saying? If the way this
absolutely.
reads is it sounds as though, and there are a lot of rights that lawyers can waive on their own. They don't need to know. They don't need to inform their
So your
clients.
point is it's got to be clear. If the defendant's not present, it's got to be clear
gotta
from
be
whatever the lawyer says that it was the defendant who agreed to waive
Right,
the
right.
right.
Because when the
That's
lawyer
really what
makes
it
a
comes
statement,
down to.
yeah, that's my point. Because when the lawyer makes
Which
a
is
statement,
exactly Judge Rivera's point in dissent in Flynn. I'm looking at her dissent here. She says, the majority's opinion risks rendering our prior decisions meaningless. That's your point. That the prior decisions about this being a right belonging to the defendant now is a right that the lawyer apparently can waive without even talking to the lawyer?
No, because if the lawyer as an officer of the court stands up in court, I understand that what the lawyer says is not under penalties of perjury, but a lawyer can't stand up in front of a judge and say, I inform my client of his antimarchy rights and lie about it, okay? There is a presumption that the lawyer is not going to perjure himself in front of the court. If the lawyer says, I inform my clients about antimarchy, then I got a problem, okay? Not only did they not do that here, but the way this reads, it sounds as though the lawyers have made the decision exclusive of their clients that this is a decision for us, the attorneys, to make, not for the lawyers to make. Okay, and just one other point, one sentence. This is a case where every single juror was brought up to the bench to discuss, out of the presence of the defendant, whether they could be fair and impartial. All of them were screened on that relevant issue first to the exclusion of the defendant, and then they took the box where they asked them questions about what color your house is and irrelevant stuff like that. This is a case where the defendants were excluded from virtually the entire relevant sections of the voir dire. I don't think this is an antimarchy issue. I think it's a Parker issue. And in the case of People versus Mitchell from the Court of Appeals, one second, they said, and this is in my main brief, quote, limited exclusion of a defendant from sidebar voir dire presents no constitutional issue. Limited exclusion. This was not a limited exclusion. They were excluded from virtually 80 to 90% of the relevant voir dire. According to Mitchell from the Court of Appeals, that presents a constitutional issue. And if antimarchy is not a constitutional issue, the only thing you got left is Parker, which is a constitutional issue. Mitchell supports my claim that this is a Parker issue.
Okay, thank you.
Good morning, Your Honors. May it please the Court, Ken Tyler for the People. I think I understand defendant's argument to boil down to you need either the defendant himself is present for the waiver, or defense counsel says, I talked to my client and he waives rather than I waive.
And here, was there a sufficient waiver?
I think there was, because I think defense counsel is expecting too much of Flynn. I think Justice Lindley hit the nail on the head when he said you lose under Flynn. That's because if we're reading Flynn as strictly as defense counsel suggests, that totally disregards the language from Flynn, which says defendant failed to rebut the presumption of regularity, and with respect to that presumption, that the waiver was neither offered by defense counsel nor accepted by the trial court without first ascertaining that defendant voluntarily, knowingly, and intelligently waived his right to be present at sidebar conferences. That is the presumption.
Right, but Flynn is, as counsel makes a legitimate point, Flynn is different as the lawyer at the sidebar outside the defendant's presence, and Flynn said, I talked to my client about it. But the overarching issue here is that this trial court, it's not hard at the beginning of a trial to advise the defendant to his face. You have the right to come up for the sidebar. This is a right that you have. You can waive that right. It seems to be so obvious that it's shocking that this doesn't happen anymore. Now, I know maybe the lawyer discussed it with him, but the better practice, obviously, is for the courts to address this issue directly with defendants, and the court didn't do that here. Now we're dealing with these arguments because of the court's failure to follow the law.
And of course, Justice Lee, I can't possibly quarrel with that argument. It could be done better. It should be done better in every case. I think it's done better in almost every case. It's an 18-year-old record, and I believe what actually happened here, whether it's certainly not ideal, but it complies with Flynn and Velasquez. Velasquez was similar in that there was a reference to a prior discussion about the Antimarchi waiver, preceded by that the sole record reference was Antimarchi waived. In this case, as Justice Sentra pointed out, there was reference to the defense attorneys having indicated that they wish to waive their client's presence at the bench, and I understand defense counsel's argument with respect to the differentiation between an attorney waiving the client's presence and the client waiving himself. I don't think that's a distinction that comes through in Flynn, because this is a statutory right related to an ancillary proceeding.
Let me ask you this. As you say, this trial was from 2000, I think? Or
I think that's right.
The appeal came up in 2002. And at the time, Lucius, we had a case called Lucius, which said that the purported waiver of the sidebar right outside the defendant's presence was not valid. So at the time of his appeal, at the time, we thought Lucius was still good law. Then we get Flynn in these other cases years later. Do we follow the law as it existed at the time that the appeal was initially argued, or do we penalize him by looking at later case law?
Well, I'm just reviewing my brief, Justice Lindley, and from what I recall, what I have here, Lucius was substantially different in that there was a confusion related to the record and a notation provided by, I think, the stenographer. And it was, I believe Lucius was sent back for clarification. It was unclear whether defense counsel was, in fact, present at the bench. And I understand your question about whether that's the law we follow now, or
do we follow the law from 2002 or the law from 2018?
Well, I would submit to you that the case is subsequent to that, and we argue this in our brief, did not materially change what the rule was. Antimarchi was always, at least with respect to voir dire, was always an ancillary right. It's always a statutory right. The ability to waive that right is more flexible. And I believe the case is Payne, the New York Court of Appeals, whether a new rule of law is really created, looks at whether there's a sharp break in the jurisprudence in that particular rule. I would submit to you there's no sharp break. These are certainly different factual circumstances, and I can't disagree that they arise under circumstances that are more favorable to the prosecution, but it's not a new rule of law.
What about counsel's argument that the defendant was excluded from important or significant questioning of the jury pool?
I mean, I guess that flows from whether or not you find the waiver to have been valid. It's true that he wasn't present as for those voir dire conferences, and they did it. It appears from the transcript that they happened pretty thoroughly during the course of jury selection. But his argument really goes to what is a constitutional requirement in Parker warnings. That's materially different to me. Those cases all arise where a defendant.
But it is unusual to, at the bench, have a juror say whether or not they could be fair and impartial. Usually when there's sidebar, it's something that would be embarrassing or sensitive to be discussed in the open courtroom.
I don't disagree with that, and I'm trying to recall the full record of the voir dire from here.
Yeah, what was unusual in this case court did a lot of unusual things, but I think every single prospective juror was called up. It wasn't like the normal trial where if somebody has something they want to discuss in private, they come up. I think every single one was brought up outside the defense's presence.
I think that's true. I mean, the record speaks for itself if I'm incorrect. I mean, the court questioned the panels more generally, as always happened, but then I believe they were brought up one by one. But I would submit to you, you started by noting that you lose under Flynn, and I still think that's correct. Thank you.
1426 People v. Stanstanek.
Good morning, Your Honors. Thank you, Your Honors. Your Honor, may it please the court, Michael C. Anfrano on behalf of Stephen Zitanek. Your Honor, with respect to my first issue, I don't believe that there was legally sufficient evidence in this case to convict my client of murder in the second degree. This is a largely circumstantial case, and if the court reviews my brief and the records, it'll show that not one person saw my client put his hands on
There's no doubt, there's no eyewitnesses to this.
Yes, Your Honor.
Other than the circumstantial evidence surrounding it and also his confession.
Yes, Your Honor.
Then is circumstantial evidence proper evidence to be considered?
Oh, of course. Absolutely, Your Honors.
And here, we have circumstantial evidence, defendant seen in the water arguing with the victim, correct?
I agree that a witness saw a person, and I don't believe that they identified that person. I might be wrong, but my recollection of the record is that if you're speaking about Mr. Abt, ABT, that he did not identify that person.
Right, but he was arguing at about the same time that your client admitted he was in the water with the victim.
Right.
Your client, there was a match of DNA for your client with material from underneath the victim's fingernail.
Yes, Your Honor.
Highly unlikely that it would be anybody else. Your client admitted he was there. He takes all her stuff. I mean, if this isn't enough circumstantial evidence, if this is legally insufficient, then there's a lot of people in jail who should be sprung immediately, because there's a lot more evidence here than in almost any murder case that I've seen circumstantially.
Well, Judge, I can't explain why my client said or did anything that is in the record, but again, as it was mentioned by presiding Justice Centra, there's no eyewitnesses. There were hundreds of people on the beach that day. Nobody saw anything. I believe there were guards.
It's not really accurate to say nobody saw anything.
Nobody saw any murder.
No, they didn't see the murder
right.
happen, but they saw him with her shortly before her body was found. His DNA was found under her fingernails. He admitted being with the victim that day.
Oh, Justice Perodato, I guess what I'm trying to emphasize is this is broad daylight. It's between noon and 2 o'clock or thereabouts.
Well, your position is that the circumstantial evidence doesn't match up to the fact that if he had done what he had allegedly had done, then because it was the location, broad daylight and everything else, somebody would have seen it. And since nobody saw it, we have to look at the improbability or the probability weighed against the circumstantial charge.
Yes, Your Honor.
Which is, okay.
Yes, Your Honor.
Okay, we have that argument, I think.
And Judge, the second point is weight of the evidence, and I would just direct the court to Dr. Spitz's testimony. And in his testimony, he had indicated that apparently the Ms. Shove's injuries were such that it didn't look like she was held down with somebody's foot underwater, and that she could have died from something other than that, and that death could have taken place, or could be the result ultimately of her hitting her head the night before.
Yeah, that's a theory put forward.
A theory, Your Honor, yes.
Okay, but there's also proof in the record that she sustained injuries prior to the death.
Yes, Your Honor, understood. Okay. And then, Judge, my third argument deals with the defendant's claim that he's been denied his right to a fair trial. As the court's aware, Dr. Stopaker testified that it was his opinion that this was a homicide. Judge McCarthy gave a curative instruction, but I guess it's my position, Your Honors, that because it's a homicide, it's a serious case, I think a jury or a juror would have a hard time following that in light of the fact that you...
Aren't jurors presumed to follow the instructions of the court?
Yes, they are, Your Honor, and that's the law.
And the law doesn't say it depends if it's a murder or burglary or...
It does not. It does not, Your Honor. But I would submit that, you know, in a case where you've got a homicide and you've got an expert testifying, maybe in that situation, maybe things should be looked at differently.
Okay.
And then, Judge, just point 4, that's the burden shifting argument. And then I submit that the comments made by the prosecutor during closing argument improperly shifted the burden. And then finally, Your Honors, point 5, I submit that because this is primarily a circumstantial case, I would respectfully request that the court reduce my client's sentence to 15 years to life.
Thank you.
Thank you.
Good morning.
Good morning. May it please the court, Amy Hollenbeck on behalf of the people. I'm not going to spend a lot of time because I think my brief lays it out, the facts and circumstances of the case and the circumstantial and direct evidence that came in that support a finding of sufficiency, and also that the evidence was not against, that the conviction was not against the weight of the evidence. I think the court has already mentioned many of those items. The DNA, the fact that the defendant admitted he was with the victim during the time frame that the medical examiners both agreed that she was likely killed.
He also admitted that he essentially confessed. He said, I did everything they charged me with. I did it all. I can't believe I did it. I killed somebody.
Yes.
He doesn't dispute that he said that.
Correct.
When he testified at trial. It's not
Correct.
like he says the corrections officer made it up. He just says, well, I was confined for so long and I didn't know what I was saying, but he confessed.
I would agree, Your Honor, and I would submit that that's fairly direct evidence. He doesn't ever mention her name. He had not been charged. He was in on other charges. He was in on a parole violation, but he essentially confessed in that unsolicited statement that he was making while he was at Jamesville. Based on that, as well as all of the witnesses who testified to the tiny little pieces of what they saw of and most significantly, Mr. Apt, who observed the defendant. I believe my recollection is at trial, he did identify him. He could not identify him from a photo array, but he identified him in trial as standing in the water with the victim, arms waving about. Some indication to his thought was that there was something going on there, that somebody wasn't happy. And the defendant then testified to seeing this person come by on his jet ski very slowly with his son, with a little boy on the back, which absolutely matched Mr. Apt's description. So based upon all of that, I would say there was more than sufficient evidence to convict. It was not against the weight of the evidence. Yes, the medical examiner for the defense did testify that he, in his opinion, there could have been traveling injuries that were observed, but the people's medical examiner was very clear on his opinion as to how those injuries occurred. In regard to the mistrial motion, I believe the court's instruction was very sufficient, very unambiguous, very straightforward, and there's no reason to presume anything other than that the jury accepted it. Also, as noted by the court, there was overwhelming evidence here to make that harmless. In regard to the last argument, our position is that it really wasn't a burden shift. Although there was an objection that was sustained, it really wasn't a burden shifting argument by the prosecutor in his closing. It was fair comment on the evidence, but even if this court finds it was burden shifting, it was one isolated comment, and the court's preliminary instructions informed the jury that any sustained objections, they should ignore what was said. Thank you.
1427, People v. Thomas.
Good morning.
Good morning, Counsel.
Unless the court has any questions, I'd rely on Mr. Monk's brief.
Morning. I would also rest on the brief. I've conceded to the Middlebrooks issue. Thank you.
$14.28 People v. Graham. Good morning.
Good morning, and may it please the court. Suppression should have been granted in this case where the police shined all lights at their disposal at my client to create the perfect, suggestive pick-me moment to the complainant. Today, I'd like to focus on the...
What about the waiver of the appeal, though?
Well,
You've got a valid waiver of the appeal. We can't address those issues, right?
I don't think the appeal waiver was valid. Primarily, the problematic with it initially is the fact that my client pled so early on, and then the court gave this elicitation of the other rights he was waiving, like the right to jury trial and everything like that. But when it came time to the appeal waiver, the language I don't think was enough to support a valid appeal waiver. It was language that suggested to my client that this was just the end of everything, that he could never come back to the court again, even for a 440 issue. I know the court didn't directly cite 440 or anything like that, but when the court says it ends here pretty much, I don't think that that's appropriate.
We have cases that, you know, they don't have to say, it says enough, basically it ends here. So what you're saying is because he doesn't articulate that it really doesn't end here, because there are certain things you can still appeal, like the sentence, if I didn't comply with it, you can file 440 motions. And because it's your position, because none of those, that word "it ends here" carves out the rest of that and of it, makes it either a perfunctory or a conflation or something, is that?
Well, that, and add to the fact that at this point in the record, there was really no discussion of the actual written appeal waiver.
Well, we don't need, if there's a good oral, we don't need a written.
Right.
Right, I would agree with that, Your Honor.
I think Justice Pedal's question to begin with is that, you know, unless we can get past the waiver, you know, how do we get to the merits?
That's correct, Your Honor.
Okay.
I would agree with that.
Okay.
But if I may briefly address the
Okay.
Second point, just briefly.
Go ahead.
You know, considering the totality of the circumstances of the show-up itself, the show-up was suggestive. We had the statements that were made by police to the complainant and the witness before they even showed them my client. They basically had my client spin around, handcuffed. But I think problematic the most, and what I'd like to focus on, is the lighting situation. Okay. We have lights from every angle. The parking lot was selected because it was the brightest in the area. So the lighting was already sufficient enough for the complainant to view my client. But then we had officers shining spotlights from the police vehicles on my client. And then on top of that, at the same time, we have them shining flashlights in my client's face.
How does the flashlight in the spotlight suggest to the witness that the police think that the suspect is guilty? How does that convey to the witness, this is the guy you should pick out?
I think it's no different than pointing fingers at someone. You know,
Wouldn't it be a stronger argument if there were a regular lineup where there are a number of people and the spotlight is on one? But here in a show-up, you just have one individual.
Well, there were two separate individuals here that were shown that night. The co-defendant as well.
Right.
But show-ups are just inherently suggestive enough. I would understand if maybe it was just a spotlight. You know, we have cases like that.
So your argument is that the additional lighting made it more suggestive. I suppose that's the argument, right?
Yes, Your Honor.
Wouldn't it be, if there's not enough light, then the argument would be, well, it wasn't reliable because you couldn't really see enough, and that would be the argument on the other hand.
You know,
They're trying to give the witness a full view of the suspect. I guess you're saying they had the full view even without all these extra lights.
Right, Your Honor.
It's an interesting argument. I gotta be honest with you. I've never heard there's not a case where there's too much lighting as opposed to lack thereof, but it's an interesting argument.
If there had just been, you know, just the overhead lighting, which was sufficient enough, but just to have this floodlight basically on the police car.
Wait,
that's right.
That's like,
all right. Thank you, Your Honor.
Thank you. Good morning.
Good morning, Your Honors. Be very brief here. There's no legitimate challenge to the appeal waiver, either that it's valid or that it precludes the suppression argument raised in point 2 for the reasons I think already cited by several of Your Honors. The show-up was not impermissibly suggestive, and with respect to each point raised by a defendant, including the spotlight issue, there's case law from this court saying that none of those issues render the show-up impermissibly suggestive. But unless there's any questions, I'll rest on my papers. Thank you.
1430, People v. Metalis.
Good morning. Dave Juergens for James Metalis. Mr. Metalis asked this court to consider 3 forms of relief. We're asking for dismissal of the felony assault, or a reduction to a misdemeanor, or a new trial. The dismissal is based on 2 different arguments, one preserved, one not preserved. The unpreserved argument is that the police officer, when he entered the parking lot to engage with Mr. Metalis, was outside the scope of his lawful duty as defined by the trial prosecutor. It was clear from the get-go that the general theory was that the officer was investigating a report of shots fired. More narrowly, his task was to go and check on bank cameras. He was on the sidewalk. He was walking towards that. There was nothing that Mr. Metalis did that prevented him from continuing. There was nothing Mr. Metalis did.
I guess the theory is affected the constant badgering, following, and the comments that are being made were being escalated to the point where he had to do something.
Well, it was comments that was made by Mr. Metalis at a time he was walking away from the officer. It's unclear, and I think the record would support that initially he didn't even know that this was a police officer.
As soon as the officer identified himself, showed him his badge, said, "I'm a police officer," basically, leave me alone. He continued to escalate after.
Well, Mr. Metalis continued to voice his opinion, and I'm not justifying what he's saying, but he wasn't committing a crime, and he wasn't committing even a harassment because he wasn't issuing any threats. He was basically walking away from this.
There did come a point in time when he became more aggressive with respect to the verbiage that he was directing towards the officer, and even his close proximity. When he kept telling them to stop, he kept encroaching upon his even arguably personal space.
Well, I agree, and I've looked at the video a number of times, and Mr. Metalis makes statements as he's walking away. It's not until the officer leaves the sidewalk, enters the parking lot, shines his light twice on Mr. Metalis. As Mr. Metalis is still walking away, after a couple of seconds, Mr. Metalis turns around. They continue to walk towards each other. The officer stops. He's pointing at his gun. Mr. Metalis walks up to him and basically continues to voice his opinion that, you just need to get out of this neighborhood. I don't want you. I think the officer is taken aback a little bit, and he's not probably used to this type of interaction, so he turns away. And at that point in time, there's an alleged threat that Mr. Metalis supposedly says, "I'll kill you." And I'll submit that there's reason for the jury not to accept that testimony. I mean, because it would not be lawful, I think, for the officer to turn around and punch Mr. Metalis in the face because Mr. Metalis was saying, "I think you should get out of the neighborhood."
But
so
don't you have to look at all the facts and circumstances and what a reasonable officer would feel appropriate in those circumstances? If he felt that he was threatened and endangered, this man was unrelenting. He kept approaching. He said, I'm here to do work, and your client just said, wouldn't have it. He's telling the officer, leave, basically don't do your job here.
And if the officer were charged with assault, those would be great arguments to justify what he did. The people seem to argue that as a matter of law, well, that gets into the justification request, but Mr. Metalis I think the problem with the people's theory is it just doesn't fit the facts, because the officer was not approaching Mr. Metalis at any point to try and gather information from him regarding the shots fired.
No.
That was their theory, and that was what they have to live with. And you know, if they had other theories that they could have raised, you know, that's for, you know,
this was bad timing. The investigator's colleague had just been shot and killed, I think, a few days before that. That may have been a factor here in the officer's behavior, may have been a factor in your client's behavior, I don't know. But your argument, you acknowledge that at the outset there was a lawful duty, that the investigator was investigating shots fired.
True.
Your point, though, I guess, is that Metalis, he was calling him a bitch and telling him to get out of the neighborhood, but he was still walking away, and that the investigator could have ignored him.
Correct.
And gone about his lawful duty. Instead, he turned, flashed his light on him and did all, and that wasn't a lawful duty. So the lawful duty ended at that point, and the altercation was just an altercation. It wasn't a lawful. I guess that's what you're arguing.
I would phrase it more that he stepped outside his lawful duty, because he still could have continued on. I think both men could have avoided this unfortunate altercation. Mr. Metalis could have kept on walking. The officer could have kept on walking.
Metalis obviously could have. Just
yeah, and
sworn at a police officer repeatedly and allegedly threatened to kill him. And I mean, he obviously could have avoided. He brought this on himself. I'm not necessarily saying that your argument doesn't have merit, but.
Well, I have to tell you something. It's an unusual set of circumstances.
A very unusual set of circumstances.
And I think the video, although there's no audio, does kind of support what took place that evening. You know, as to walking, who stopped, who did this, who approached who. So, well, obviously we have to look at. We'll look at that issue.
And the second preserved issue is directly related to the first issue, is where the defense attorney did argue that under the totality of the circumstances was legally insufficient evidence to show that Mr. Metalis intended to interfere with the officer checking on the bank cameras. And I'd say it'd be a different story if Mr. Metalis had, while the officer was walking towards the bank cameras, had tried to interfere with him continuing on. Then that would have been legally.
But the investigator told him he was investigating shots fired. He showed him his badge, showed him his gun, and then your client wouldn't let him. I think your stronger argument, I'm not necessarily saying meritorious argument, but the stronger one is physical injury. I mean, the photographs, I have paper cuts that appear more severe than some of these scrapes and cuts that.
Well, I'll move directly to that. We're asking for a reduction to the lesser included offense of obstructing governmental administration. The officer had no treatment. There was no loss of work. Minor scrapes. He said his pain level at the day of the incident was 4. He says that the next day up to 6, but I don't know that there's a direct proximate cause between that and the 50 to 100 other altercations that he's had in his past history, and it's just a fact of getting older that some days you wake up and things are stiff and sore, and I don't think.
Well, I think you're mentioning, it boils down to, and I found interesting, the substantial pain. Testified he got a cut left wrist, cut to his left elbow, cuts to his right knee, cuts to both the top of his hands. Jaw was sore, eye, talks about the eye open, liking this, looking through it. His shoulders were very sore, his right knee was also cut, as you indicated. He said on a scale of 1 to 10, I think it was a 4, but as it progressed, it turned to a 6. So the question becomes, is based upon all that testimony and the way he rates his own pain, does that rise to the level of substantial pain under the definition of the penal law?
True, and looking also at there has to be some objective corroboration to whatever his subjective testimony is. I would just note that there was no testimony when he's talking about 9 months later how he's having a hard time lifting things over his head. There was no testimony establishing that he didn't have those same problems before this altercation, which, by the way, was 40 seconds on their feet and 40 seconds with the officer, 6'3", 240 pounds, on top of Mr. Metalis before the other officers arrived. It was a brief altercation. And I think that there's a substantial question on the physical injury. We do make 3 arguments that I'll address very quickly for a new trial. They're all unpreserved, but I think they're all fundamental in nature. Under point 3, the court removed an element from the jury's consideration when it instructed the jury that an officer is authorized to investigate shots fired report.
And that's reference also to the OGA?
That was the OGA, but the combined effect of the fact that there was no instruction on lawful duty for the assault, and then you have a directive to find it's not lawful duty, it's official function, which are equivalent elements. I think that removed that from the jury's consideration. That's a fundamental error. Point 4 is justification. Contrary to the people's argument, I think there's a jury question as to who is the initial aggressor, and certainly...
you think the court should have sui sponte have done that?
I think it should have sui sponte, and then going into my last argument, I think the attorney should have raised it, and given the circumstances that it was ineffective not to argue that, you know, Mr. Metalis, when he counterpunched with the officer, was not intending to stop him from checking on the bank cameras. He was acting in self-defense, and that certainly could have been something that the people couldn't prove beyond a reasonable doubt if that was given to the jury. And there was no legitimate reason for not attacking the lawful duty element.
Thank you, Counsel. Good morning.
Good morning again. Dan Gross on behalf of the people. Starting first with the legally sufficient evidence, I'd agree with the court that this is a bizarre set of circumstances, and I'm particularly happy that there is video corroboration in this case, because this the testimony just doesn't seem to make sense, the way the defendant escalated this interaction with the police officer who the video shows was merely walking down the street investigating a recent shooting. Under the defendant's argument, the fact that the police officer's performing one task would preclude him from investigating any other task that he might encounter along his way. So I submit that the lawful duty is not required to one specific task, and I think that carries over into the defendant's specific intent. There's no specific intent required. Moving on to the physical injury element, I would agree that that is a closer question in this case.
What's your best case in that issue? Because it looks to me like most of the cases go the other way. So I'm troubled by that in particular in terms of the proof of that. What's your best case in that issue?
As far as the specific case goes, I think it's more of a general application of the rule, Your Honor. The police officer, I would agree that the photographs are not as troubling as certain paper cuts, I guess, but the testimony of the officer in that once I'm done testifying today, my knee is going to hurt because it's going to be in a locked position. As a result of this, this encounter also aggravated a pre-existing wrist injury and the fact that he could no longer sleep on, I believe it's his left or his right side. And again, this was all attributed to the encounter with the defendant. So while I agree that this is a closer situation, I still think that physical injury has been met here.
Is there any objective component to a subjective complaint? Does there have to be? Can it just be totally subjective? I had substantial pain, 10 out of 10. Is that enough?
Well, it's just a factor-based consideration.
But don't, in those situations, don't you take into consideration what he said, coupled with the types of injuries that he has?
Well, I think...
So there isn't just totally subjective, there's some objective observations.
Well, again, I would go back to the videotape. You know, there's photographs of the crime in the aftermath, but there's also the videotape. And I know 40 seconds in the scope of maybe reading case law isn't that long, but 40 seconds in the scope of having an altercation with a defendant who's just...
Who's reaching for your gun.
Who's reaching for, well, allegedly reaching for your gun and threatening your life, and has made the decision to follow you as you attempted to de-escalate the situation. I think that would support his claims for injury, and that would be an objective component this court could consider. Unless there, just moving on to the argument regarding the court's instructions, that's unpreserved. I would note that the court followed the CGI instructions on both, and that the OGA instruction was requested by defense counsel. Unless there are any other questions, I would rest on my papers for the remaining arguments. Thank you.
Thank you. 1431, People v. Hicks.
Morning. Your Honor, may it please the court, Sarah Goldfarb on behalf of Appellate, Mr. Valeen Hicks. Mr. Hicks was given less than 24 hours to consult with counsel and exercise his right to testify at the grand jury. This was not a reasonable...
What about the fact that he's been writing, his girlfriend has been telling the lawyer he wants to testify?
I'm not aware that that was given to the attorney who was representing him at this time, but I don't recall that.
So it wasn't clear the client did make it clear what his intentions were prior to those 23 hours?
Not to this attorney. As far as I'm aware, I could be mistaken. But this attorney had been assigned within the past couple of days. And it's not clear on the record whether he had even met with Mr. Hicks yet.
Here's where I think, I don't find those facts as much, the facts I find more pertinent here are this, that the attorney did receive a fax from the DA's office that they were going to present it the next morning.
That he did?
Yeah.
Yeah, he
The
did.
attorney did.
Yeah,
And so your argument is the fact, since he only had 23 hours, that was insufficient time for the defendant to make a knowledgeable or type of educated determination of whether he wants to testify or not.
That's correct.
Okay. And because the case you cited to was it Himes, or one of the cases in there deals with a short period of time that we have from the 4th Department. That was dealing with, even though there was less than 24 hours, he had no lawyer in that case. There was no, and what happened was his lawyer stepped down, and the next morning he was assigned a new lawyer. At that time, he'd already been indicted. So I think when we talk about the time frame, I think that's distinguishable between this case and that case.
Right, and that's certainly a distinction between this case and Himes, but there are other cases, such as the Peters case, where, you know, even when there was an attorney with 2 days to meet with the client, that was still not enough time to allow the client to make a educated decision about whether he wanted to exercise his right.
Didn't they have more time, the defense? The notice was served, as Justice Centers indicated, 10/21 on May 19th. And the grand jury was hearing evidence the next day, the next morning. But the correct? Notice was on the 19th, grand jury presentation started on the 20th.
On the 20th, yes.
The indictment wasn't handed down till much later, correct?
I believe the indictment was handed down.
A couple months later. Yeah.
Right, so couldn't, if the defendant really wanted to testify, couldn't they have served notice to the DA after the 20th and said, could you get my client in, and they could reopen? It wasn't too late, in other words, right?
I'm not sure whether it was too late or not, but that wasn't a reason that the lower court used to deny Mr. Hicks's motion, so I don't believe that under Concepcion that's a reason for this court to affirm the lower court's decision.
Okay.
If there are no other questions on that point, I'd just quickly move to the second point, that reversal is required here because Sergeant Proud offered improper expert opinion testimony and supplanted the jury's fact-finding role. During direct examination, the prosecutor asked Sergeant Proud, is there any question in your training and experience that the cocaine...
That's clearly improper, right?
Right, yes.
So we have to do a harmless error analysis?
Correct, and I would argue that in this case it was especially harmful because there wasn't overwhelming evidence of Mr. Hicks's guilt on the intent to sell charge. The officers testified that they found the cocaine under his body in an unrelated party's front yard after a police chase. The police did not observe any hand-to-hand transactions, and so it was really just this mere fact of possession that they were using.
Let me ask you a much more fundamental question. Is it preserved?
Is it preserved? No, it is not.
And now you're going to argue because he was pro se that he doesn't have to preserve it?
Well, just that he shouldn't be expected to understand the intricacies of that.
Before he had a lawyer, the lawyer started the examination. He chose to take over for his lawyer. The court said to him, I'm going to hold you to the same standards as a lawyer. So now we have a new rule that says that, because I haven't seen a case, and correct me if I'm wrong, where when somebody's pro se, they don't have to preserve because they don't understand what preservation means.
Correct. I would just argue that that's just something this court should consider in its interest of justice jurisdiction, because but for that testimony, the jury might not have acquitted him on this point. Okay. And if there are no other questions, then I rest on my brief for all other points. Thank you.
Good morning.
Good morning, Your Honors. Brad Osler on behalf of the people. May it please the court. I'd submit that the notice provided here by the people was in fact reasonable. Not only do we have the defense attorney acknowledging receipt of it, there was a full 23 hours, nearly a full day of time for him to consult with his client about testifying. I think the cases that were touched on briefly are distinguishable in that if there was not an attorney assigned, then there's not going to be able to be a reasonable chance to consult with an attorney to make the decision about testifying. There's there's no hard line, obviously, when it comes to notice, and I don't think we should try to establish one. The idea that there just needs to be reasonable notice is appropriate. And we look at here where we have confirmation that it was received. There's no reason to suggest that that's not a reasonable standard. Touching on the expert testimony, I would agree with the panel that it was an unpreserved argument. I know that the appellate divisions typically will reach analysis of it anyway, but much like Goodwine in the second department, Wright in the third, and then Hartzog here, it really was harmless error. It was a very brief exchange, and the underlying facts about the drug possession and the amounts certainly would allow the jury to reach the conclusion there was intent to sell.
Thank you.
Thank you.
$14.32, People v. Balkman. Good morning.
Good morning. Janet Soames on behalf of Everett Balkman. The sole predicate for the stop in this case was the computer-generated alert which notified that there was some sort of similarity between the registered owner of the vehicle that was stopped and a person with a warrant out of Rochester City Court. As it turned out, of course, there was no warrant and there was no other basis to stop this vehicle.
Go ahead. You first, John.
The defendant was a passenger in this vehicle, right?
Yes.
I don't see that any standing issue was raised below.
There was no standing issue raised below. And as a passenger, he was stopped. His physical, progression in the car was stopped. He absolutely there was an intrusion on his privacy rights here, absolutely.
He was not charged under the automobile presumption, though, was he?
No.
Yeah.
No. The people cannot rely on a warrant that doesn't exist. And here, there is no doubt that the warrant did not exist. The Court of Appeals made clear in Jennings.
With respect to pulling the car over and the reasonableness of the police action, they had information that connected this particular car. So you're saying the police couldn't pull the car over until they knew for sure?
Absolutely, that's what I'm saying. Reasonableness does not come into the equation. This is action that was taken on a supposed warrant. And the officer did not even reasonably, he never even testified that he thought there was a warrant.
So is he supposed to keep driving and reading a computer
Yes.
screen?
Yes, he can drive, he can read the computer screen, he can call out to someone to do the check to find out whether or not there was a warrant. Reasonableness doesn't come into play here for a lot of reasons, but one is the officer here never said that he thought that there was a warrant. He said he just got this information. He may know that this information turns out to be not valid in a lot of cases, so he never claimed to have
The question, to me, it boils down to is with the similarity or similar hit is really what the computer does. And the question becomes, based upon a computer finding a similar hit, whether it be name, whatever it may be regarding a warrant, whether or not, I look at it as whether or not that rises to the level of reasonable suspicion, because it would be a loss to pull a vehicle over. And normally on these cases, you said you don't take in reasonableness, and your argument really boils down to that may have just piqued his interest, but he had to take one more step in order to make that stop.
Yes, and reasonableness often turns on a question of whether or not there were less intrusive alternatives to the police action, and here there were less intrusive alternatives. One being that even after the car stopped, he could have then checked the computer. It was right, the information was right at his fingertip. He absolutely had the ability to find out that there was no warrant right then and there before he even approached the car. I don't know if you all get stopped by the police, but there is also usually a long period of time between the time that they stop you and they approach my car. And that is probably when.
Nevertheless, even if they eventually walk up to the car, have a good day, they approach the car to give the driver the indication that they are free to go about their business.
They could have done that, yes.
But when he gets out of the car, he sees the gun on the floor. You're saying before he got out of the car, he should have known that the warrant was good. Then how would the driver know that they are free to leave if the officer doesn't approach and say you're free to leave?
I think that there was a time period from when he approached the car. He didn't immediately see the gun. He approaches the car. He explains that, he thinks that he got an alert for a possible warrant. He talks to the driver for 20 to 30 seconds, he says. He demands that she produce identification, even though she's done nothing wrong, no V&T violations, nothing. He demands that she give him her ID. And then he starts looking at the registration sticker. He starts looking at the inspection sticker.
Right, he was fishing.
So he's got some time. He's fishing.
He was fishing when he ran the plates on his computer in the car. It was 4 a.m. He was curious. I mean, I think the police would acknowledge they do that all the time.
Mm-hmm.
And but I guess your argument on Jennings really comes down to the warrant was invalid. It turned out to be invalid. Even if it was good faith basis for the officer to believe it was valid, it turned out to be invalid. The evidence obtained as a result of the warrant should be suppressed. But here it's a little different than in Jennings. Jennings, the warrant, they arrested the guy, and then a search incident to arrest, they got evidence. And then the court had thrown it out, saying that even though the officer believed the warrant was valid, it wasn't in fact valid, so everything gets suppressed. Here, though, if they had taken your client into custody on a warrant and got evidence, then Jennings would apply. But here, the officer saw the gun before he even acted on the warrant as far as taking anyone into custody. So people argue that's different. This is different than Jennings. They saw the gun. They didn't get it in a search incident to arrest on the warrant.
I'm arguing that Jennings should apply even though my client was not arrested immediately, because this is a substantial intrusion on his privacy rights. We know from Delaware versus Proust, the Court of Appeals, we know, or the Supreme Court, we know from the Court of Appeals cases that this is a substantial, it's a seizure, and he's seized at the time that that car is pulled over and cannot go forward.
Based on that, isn't your argument really that they should have gotten confirmation on the computer before they even pulled him over?
They could have done that. My argument is, yes, they could have gotten confirmation before they even pulled him over. Second of all,
so you're with that argument, they would have had to continue to follow this vehicle while they're getting confirmation, and that would not have taken that long and would have been a reasonable course.
That would have been a reasonable course, or even checking the computer after he stops, if he was unable to fiddle with it while he was.
I thought your whole argument, like Justice Peridotto says, it's all right before the stop. Until you activate the lights, that's the question we have to evaluate. Was there reasonable suspicion? And your argument is in evaluating that, we have to look at the other alternatives as to reasonableness, correct?
Absolutely.
So the officer could have followed and gotten on the radio, which I thought was your primary argument, right?
That's what best.
So it's all before the stop. We don't even get into the mistake of fact issue. The question is whether or not there's reasonableness by virtue of that computer check. And I suspect maybe you're going to tell us too, given the availability of information now through these computer checks, which system was this, do you know?
I don't.
Well, getting back to that too, shouldn't we defer to the trial court's evaluation of the credibility of the officer in terms of the composition of what the report was? As I understood the record, it looked like he was basically saying, I thought there was a warrant.
He never says, I thought there was a warrant.
He comes close.
He says that, I got the similarity hit. But there's no basis, whether or not he reasonably relied or whether or not there was a similarity. You need to have facts in the record to conclude that. Here we don't have any facts. We don't know what the similarity was. What was the supposed similarity? Was it a similarity of names?
Can I just clarify one thing before you're done, because you've been up there a while? This similarity hit, that wasn't a determination made by the officer. That was made by the computer system, right?
Some computer system, the parameters of which we don't know.
Hit. And so you're saying he's got to look beyond similarity to find identical. He's got to look beyond that. He can't rely on what the computer is saying.
I think he could, but the people didn't show what he relied on. The people could have said, here's what the warrant was. The warrant was for, John Doe, blah, 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 date of birth, blah, and here's what the registered owner's information is. So once that information is presented, the court can make, you can make, review whether or not there was a similarity.
We don't have any idea how similar the name was, the date of birth, anything, right?
We've got nothing. Yeah. We've got nothing for this court to look at. Similarity, a determination of reasonable needs to be based on facts, and here we don't have the facts.
Shouldn't that be preserved and teed up properly?
I think it was. Absolutely.
Okay, in terms of, like, I sort of expected to see a printout of what the screen looked like coming into evidence, but there was no objection as to the absence of that.
I think that he didn't need to object because it just wasn't produced. The people didn't meet their burden.
You're saying it's a people's burden,
It's a
right?
people's burden, and they didn't meet it by failing to bring this evidence forward. Thank you.
Good morning.
Good morning, may it please the court. Lisa Gray for the people.
What do you say with respect to the claim that there wasn't sufficient facts to establish what the similarity was?
Well, I believe that the evidence elicited at the hearing was that the police officer testified that there was a similarity hit. The officer described what a similarity hit is. And also in this particular case, the police officer made mention that when he runs license plates, he will get warrants coming out of far-flung jurisdictions, Florida, other states, New York City. But in this particular case, it came from the city of Rochester, which in his mind gave it more credibility.
But do we know there was a warrant out for somebody? We don't know the name. I'm not even sure we know the name of the registered owner of the car. Was there any evidence as to how similar the names were, how similar the date of births were, anything like that?
Not in the hearing, but for the purposes of the hearing, I would suggest that that was not important in that the police officer, there was a similarity hit for a warrant out of the city of Rochester. So I want to sort of clarify a little bit. It's my understanding from reading the hearing testimony that there was a warrant out of the city of Rochester, which is a question of was it the registered owner or was it person B? And for that reason, the analogy with Jennings fails because there was no testimony saying that this warrant was invalid, non-existent, vacated, the system wasn't cleared of stale information. There was a warrant. It just ended up not being for the registered owner. And as recently as 2017, the Court of Appeals in Bushy has said that running a plate gives the police officer a level 3 reasonable suspicion to pull a vehicle over. So I think similarity hit, I think maybe that information might have been superfluous at the hearing. We don't really need to know what that similarity hit was based on.
But it strikes me as it's important to know how does the computer generate the similarity hit? Like what, we're being asked to rely on the accuracy of the similarity hit. And we don't even know how similar the information was, how similar the names and date of births were. Because we're just supposed to trust the computer system that when it says similar, it is in fact similar.
Well, I think, again, in Bushy, the Court of Appeals said the police officers can rely on information that is relayed to them when they run license plate checks.
I guess what the problem becomes is that, from our view, and this is my view looking at it, if it came back similar, it was to a John Jones, Afro-American, and actually the car is owned by John Smith, a Caucasian, there's no similarities there. And so the fact of the matter is that, just because the computer says what the computer says, is that we take a blind leap of faith without having a printout that there was some similarity, like as to the reliability of the similarity set. I mean, you can see you have.
I do. I see what you're saying, Justice Sentra. But getting back to my initial premise is that by running this plate, it provided the police officer reasonable suspicion to approach that driver.
Well, based on what? Based on what? What's the reasonable suspicion? I'm sorry, Justice Sentra.
Based on the information received
which was
from
what?
which was this similarity hit. There's a warrant out of the city of Rochester
for
perhaps the registered owner of the vehicle.
Maybe.
Perhaps. There was some similar pedigree information.
Right. But Ms. Soames has that right that the officer didn't actually go that far, right?
He did not, but you also, I think, should note that the police officer testified the area of the car stop was also an area where he was familiar with, and although perhaps didn't necessarily articulate this, I think it can be inferred from the testimony that basically he didn't want the car to get away. It was a place in the city of Rochester where people could flee or hide or whatever.
But her also point is that when he pulled the car over, he could have simply waited an extra 60 seconds, confirmed whether or not he's got the right car or not the right car, that he could have called it in, he could have done other steps while following the car.
Yes, he could have, yes.
That's where the argument is that it would have been a better practice to do that. Whether they're required to is obviously an issue.
Right, but also I think that leads back to what Justice Troutman was saying, that eventually he would have to approach the car, and at that point he's lawful in letting the driver and
And the
passengers
problem
go
is
away,
then we start-
and then you're in a plain view
Yeah, but then we start
situation.
to speculate because he was there for more than 3 seconds, is you can go. I had the wrong car, as opposed to the time it took, that ultimately he did see it. So we'll look at those
Well,
issues.
here's my question, though. Do you think that the people have the burden to establish what that computer actually said? And isn't the best evidence thereof a printout from it or a redemonstration of it? I mean, don't the people have that burden?
I don't know that the people have the burden to present printouts or computer documents from these mobile data terminals. I think the best evidence is the testimony of the officer who was there, his recollection of events and the information that he was receiving at that time. I think, and I think in this case, the people certainly met their burden at the hearing level. Thank you, Your Honors.
1433, matter of Emmerich. Good morning.
Your Honors, thank you. Mindy Marenka for the 3 minor children, Serenity, A Miracle, and Solomon. Certainly, I will rely upon my brief. Very briefly, though, I do believe that this decision was made on a default order, and the court does not have the jurisdiction to review such an appeal of that order. If for some reason
we don't, then we get to the best interest.
Correct, and absolutely based on the deference given to the trial court and the evidence presented by the medical witnesses as well as the caseworker witnesses, this mother had severe mental health related issues, and the conclusion of a neglect finding against the mother on behalf of my clients as well as the 4th child in this matter was certainly proper. There was a lack of care, a direct risk of impairment for the children, and an effect on the children. My 9-year-old client was left to cook for the family, to get her brothers and sisters up for school, and essentially to maintain the household when her mother was having anger management issues, was hiding in the household, and certainly berating caseworkers that would come to her home.
Thank you, Counsel.
Thank you.
1434 to 1436, matter of Ashenet. 1434, 1436, deemed submitted. 1437, Gatto v. Roman Jr. Good morning.
Good morning, Your Honors. May it please the Court, Nancy Kober for the appellant. Your Honors, it's respectfully submitted that the lower court erred in failing to grant my client, Dion Roman's, motion for summary judgment upon the grounds that he did not owe any duty of care to the plaintiff, Santina Gatto. The record before this court establishes that my client, as the insurance agent, procured a homeowner's policy for a Yvonne Rubino.
Right, we understand the facts, and you've laid it out in the brief. Are you familiar with a case we decided last year involving Allstate? It's called Nicotera versus Allstate. Are you familiar with that case?
I don't think I
know
reviewed
opposing
that one.
counsel is because their office represented the plaintiff in that case, but the case appears to be on all fours with ours, and that would support your position. But you haven't looked at that case, I assume. I hate putting lawyers on the spot with.
No, that's okay,
But
Judge.
he just did.
I researched it, and I did not see that particular case. So I apologize to the court, but.
Basically, in that case, we held that there's no duty unless the agent is asked to procure specific coverage and fails to do so, or if there's a special relationship. There's different ways a special relationship can be created. They're relying on the one exception here. The one way to create a special relationship is through expertise, relying on their expertise. I think that's the only basis for the special relationship they're relying on. And your argument, because there's issues of fact all over the place here. Would you agree?
I respectfully disagree, Your Honor.
You don't
That
think
case that you cited is obviously the general rule of the state of New York, which is if you have a special relationship, you may have a duty to advise. In this particular case, however, the only insured and the only customer of this agency was Yvonne Rubino. She died When she died, the authority of the agent to act on her behalf ended. She did not have a personal representative appointed.
I didn't say there were material issues of fact.
Oh.
There are many issues of fact. Did the daughter, the eldest daughter, talk to the agent? Did the daughter tell the agent that her mother died? Did the daughter pay the agent directly on those phone calls? Those are all sharply in dispute. Those are all issues of fact. But let's assume that all those issues of fact are decided against you. Your position is that you still win. There's no duty, even if all those phone calls and communications were made.
Judge, let me just talk about the phone calls first, okay?
I guess the question that's being asked is, and I don't think you're getting it, is there's issues of fact and what he said and what she said and what was done. What Justice Lindley says, assuming for the worst argument, for this argument, that they're all decided against you, it still doesn't give them coverage.
Correct.
Because it doesn't matter. Because the only way you get there is if you can establish some form of a special relationship.
Correct.
So assuming that you can argue each of those facts, that why they're not questions of fact, but at the end of the day, on a motion for summary judgment, and assuming what we do, we look at it and say that they're against you, you still win.
Correct.
So that's the question that's being posed.
Correct. Because, Your Honor, the only duty that is owed by an insurance agent is to its customer. Its only customer was Yvonne Rubino. Ms. Tomeno had zero authority to act on behalf of anybody here. She didn't represent the estate. In fact, her siblings specifically refused to allow her to be appointed as a personal representative for the estate. Nobody represented the estate. The state is not a separate legal entity.
Let me ask this question. Assuming for this argument that she did speak to the agent, and assuming that there was a potential special relationship, then it'd be a different scenario.
I respectfully disagree, Your Honor. You cannot call my agent and create a special relationship without my agent agreeing to that special relationship.
No, I'm not saying that. I'm just saying, assuming for argument's sake, that the only way they get there is by them establishing a special relationship.
Well, before they get to a special relationship, they have to establish a relationship. They have not established a relationship because Ms. Rubino she was not a customer. I mean, Ms. Tomeno admits she was not a customer of my agency. Ms. Gatto was not a customer of my agency. Who are we supposed to get the insurance policy for? There's no estate. It's not a separate legal entity. There was no personal representative appointed that could be named to buy the insurance. And with respect to Ms. Tomeno, with all due respect, I understand that she has a recollection, but her recollection is directly and utterly refuted by the documentary evidence that shows there were zero payments made to my client. Her credit card statements also indicate that she's calling Allstate Service Center, not Mr. Roman's office. There is zero evidence in this record that, number one, my client was aware of the person dying.
There is evidence under oath from the older daughter that she called and said, I spoke to him and told him my mother died. But what we seem to all be saying to you is, even if that happened, you win anyways.
Correct. It's a matter of law.
So you want to argue these non-material issues of fact when you should be focusing on the law.
I certainly do not, Your Honor. Under the matter of law, there's no duty owed by my client. In the absence of a duty, there can be no breach of contract as a matter of law. Those are issues that I've talked about.
And that's what we said in the case that he mentioned earlier. Unfortunately, you didn't read it, but it was...
I appreciate it.
So we're coming from a point that...
Right.
Okay.
And I appreciate that, Your Honor, but that's also the law under Murphy v. Kuhn throughout the state. Thank you.
Good morning.
Please, the court. I wasn't expecting to relive history with the Nicotera case.
How would you distinguish Nicastro? I had a hard time distinguishing. I mean, it's very similar in a lot of regards.
I think, at the risk, I don't want to mix the two together, but I think the issue really is because because Mr. Roman is a captive agent for Allstate. It's that idea of respondeat superior. When Mrs. Tomeno calls and says, you know, my mom passed away, not once but twice, by the way, because she did testify about how he talked about my brother and playing ball, and then, you know, I was annoyed that I had to tell him again, and she specifically said that.
Does he have a duty to tell her you should take a certain course of action, even if she told him?
I believe that for two reasons I believe that he does. Number one, if he can't procure the policy, he has to tell her. So even if she's a new customer, suppose for the sake of argument, which I'm not conceding the point, but suppose for the sake of argument that she just presents as a new blank person, he still has to tell her, I can't do what you're asking me to do. No matter what, he has to do that. But I also don't think that we fall under Murphy versus Kuhn, because any statement to the agent is a statement to Allstate because of respondeat superior. He is a captive agent.
Right,
he works for Allstate only.
We have
Yes.
two causes of action, one against Allstate for reformation of the contract.
Yes.
And another against the agent for negligence. For reformation, you can't change the material terms of the contract. And here, you can't change the insured, you can't change the fact that she was supposed to live there. So, and that's what we said in the other case from last year. This one, the agent in the prior case was a captive agent as well.
He was, but the facts were a little bit different in Nicotera. It was a two-family home, and there was a niece or something, granddaughter, niece.
It was a niece.
Okay, thank you. Living in one of the units, one of the flats, but not in the flat where the insured had resided. In this case, it's a single-family home, and it's an unfortunate circumstance. They have 8 children, and there's a daughter who could never live independently. She lived with her mother always, and there was testimony about that from Mrs. Tomeno. Her first name is Marcella. And then the son, Marco, who oddly enough is the one that they sort of kibitzed about when they were talking on the phone. He also was a bit, I don't want to disrespect him, but he was not living on his own frequently. He was in and out of trouble and incarcerated and different things in his life. So he was in the home pretty much, if he wasn't in jail, he was in the house. And Marcella always lived there. So the composition of the household, Mrs. Rubino can't live there, she's dead. Allstate knows she's dead. They can't shield themselves from liability. I'm sorry?
Who's the
The
client?
customer, you mean,
Who's
or the
client that the contract was made with for insurance? The decedent, correct?
Well, there's the insured and there's an insured. So we have the insured was Mrs. Rubino, who was deceased, and
So you're saying because the other people were living there on and off, they're uninsured?
well, Marcella lived there. That was her residence. She lived there permanently, and at the time, Marco was residing there.
I guess the question is that
Yes.
the policy is written for the owner and who's residing there. The owner was not residing there.
Right.
In the
And
same case you had with us before, the owner resided in a nursing home. In this case, the owner was deceased. So when we talk about reformation of a contract, we're dealing with the fact is that we don't have the owner living there. We don't have them, and that's what the contract called for.
right, regarding the reformation issue, I think there is this difference between an insured and the insured, and also the idea that Allstate intends to insure any company. They don't insure people, they insure premises, they insure the household. It was still occupied full-time, nothing about the house had changed.
Occupied by somebody who wasn't an insured, a named insured though.
Well, they were not the insured, they were
not an additional insured either.
they're an
Named.
insured under the definitions of the policy, though, Justice Lindley.
And insured because they're there because they live there with the owner, correct?
I believe I would have to check the definition of the policy, but I believe
Yes.
it's residing there.
Residing with the person who doesn't reside there anymore.
Well, I think the definition was residing there. But this is troubling because the agent, I mean, we get a little into the reformation issues and the policy issues, but the agent isn't in privity of contract, so I think that the idea of the insuring agreement, all of those things, I don't think Mr. Roman can assert those. But I also think that it's, how can he use the fact of a person's death to require the person to report her death? It's mind-boggling that when he was told twice and did nothing, I think he's negligent for that. It's a problem because of respondeat superior, because he's a captive agent with Allstate. I don't think we get into Murphy versus Kuhn. And he was under an obligation to say, even assuming for the sake of argument, Mrs. Tomato comes in as a new customer, blank person with no history, he still has to say, I can't do what you're asking me to do.
I agree with you that there may have been negligence, but without duty, it doesn't matter. And this is a duty issue. So we don't even get to negligence. But we'll take a look at it. Look, I think the trial judge was sympathetic to your clients. I'm sympathetic to your clients. Nobody's sympathetic to Allstate. But there are laws here that have to be followed.
I understand that, but with respect, I think it's worth just saying again that he does, no matter what, owes a duty to say, I can't do what you're asking me to do. Whoever it is, if I call, if one of the justices call, he still has to say, you want that thing, I can't do it.
Fair enough.
Okay, thank you.
1440 for Call of East First Choice Realty. Realty? Good morning, sir.
Morning. When the Constitution was finalized, James Madison stated the Constitution will be the law of the land. However, judges will be the politics. This case is about political judges, abuse of power against legislative commands, under the Business Corporate Law, Section 1005, Subdivision A, 1, 2, 3, capital A, capital B.
Sir, let me cut to, because you have limited time, and I want to make
Your
sure.
Honor.
No, excuse me.
I don't hear so well.
Okay, I'll be a little bit louder. You have limited time, so I'm going to try to help you here so we can get to the issue. We understand, we've read your material. Your position is that the stipulation regarding the Playtime Boutique in 2003 order, okay, and should be the one that's followed, the transferring of the real property in accordance with the 2005 stipulation was fraudulent. So your position is, because you're suing under a different name this time, therefore collateral estoppel and res judicata are not applicable. So you're arguing you're a different party today. You're not the same party that lost before.
Yes, Your Honor, yeah, that's basically the situation, but there's more to it.
And because you're a different party, you're not bound by those, the res judicata or collateral estoppel.
Yes.
And that allows us to take a look at whether or not the transfers of the property that you're alleging there, the different properties, whether or not they were fraudulent, and if they were fraudulent, whether or not these parties in which you name, they participated in the fraudulent conduct that you're alleging that they did, they participated in, and therefore they're responsible.
Yes.
And that's how you bring them into the loop, because you know that you're prohibited from bringing a lawsuit under the original party, is the original party, because you've brought it, you've lost it, you've brought it, you lost it, and so now you're saying, hey, that was a different party, that was Choice Realty, I'm Playtime Boutique, correct?
Yes, but the corporation before the court, Your Honor, is First Choice Realty, Inc.
Yes.
And the dissolution of that corporation has been hindered because of the stipulation you referred to, Your Honor.
The stipulation in 2005.
Yes, Your Honor. Except that it's all, we went through a lot of court procedures to try and straighten it out. However, to skip through what I was going to say, make it short and sweet, Judge Hester, in a bench decision on January 16th, 2014, when the courts were saying, including the Fourth Department, hey, Judge Groh gave an order, so that's it. So we went through a lot of routine and to try and resolve these situations.
You've been here a few times.
I'm sorry?
You've been here a few times.
Yeah.
And I've been in.
Not by choice, Your Honor.
Well, you filed. Okay. Even though you said below you weren't going to file an appeal, you were handed it outside the court system, but.
But Your Honor, nothing was straightened out until January 16th by Judge Hester. He straightened it all out eventually. When he decided there was an action brought to vacate that so order by Judge Groh on that stipulation. Judge Groh, when he gave that stipulation, there was no notice, there was no hearing.
Okay, see, here's where we have a problem, at least with me. The issue with Judge Groh has been litigated more than once. We've affirmed him more than once. You've been sanctioned at least once as a result of these actions. I look at this case as you trying to say you have a different corporation that was entitled to the proceeds or benefits that they weren't given as a result of the 2005 stipulation, and therefore my cause of action now is different from the ones that I previously lost.
Yes.
Okay. So if we find that's the case, and this is an independent corporation that was entitled to the proceeds, we then have to look at whether or not the real estate transactions were any fraudulent, and if they were, whether or not these parties you named here were part of the fraudulent conduct. And if so, you want this case reversed, go back and do discovery so you can pursue your action.
Yes.
Okay, we'll take a look at that.
Okay. Thank you.
Thank you.
So let's take a look at the transaction that we were talking about. First of all, we have an order by Judge Groh in 2003, and the order by Judge Groh states very clearly, order, Albert G. Fercola Jr. as president of First Choice Realty be empowered to collect all rents presently owed to First Choice Realty. And it is further ordered that Albert G. Fercola Jr. as president of First Choice Realty be empowered to take all necessary steps to collect back rents which are due to First Choice Realty, including but not limited to evicting any tenants who refuse to pay the stipulated rents. Judge Groh goes on to say, order that Albert G. Fercola Jr. and Phyllis Fercola agree to a fair market value of the real estate, including the value of current tenants owned by First Choice Realty, Inc. in Troy, New York and Marcy, New York. And in the event they are unable to agree, then an appraiser will be appointed by the court.
Okay, sir, we know what that, we've read that. What we have to do is see what the interplay between the 2003 stipulation and what the interplay is what happens in 2005, whether or not that still survives or not. And so what I'm trying to explain to you is, as you can see, we're aware of this. It's not the first time I've read your prior cases. We will look at that argument, but my main concern right now is whether or not you get past the first hurdle, not the merits, because if you get past the first hurdle, then there may be some merits to your argument. Our job, I believe, at least speak on behalf of myself, is to see whether or not those prior decisions we made foreclose you from bringing this, and that's why I've been trying to focus on. I understand if we get past that. I don't think your colleague over here will disagree with that. The hurdle here is a procedural hurdle that must be overcome. So we're going to look at the procedural hurdle. If you overcome the procedural hurdle, then we're going to be looking at your merits.
Okay.
Fair enough? Okay.
All right. So there are two deeds that are prepared and filed.
Okay.
This is the action. This is the action. The deeds are the action that creates the case for obstruction of justice here, for violation of the legislator's commands under the business corporate law.
And do you understand, sir? We recognize that. I'm telling you, we recognize it. We have your argument. Our focal point is the procedural issue. If you get past the procedural issue, those arguments you raise may have some validity to them. But we have a procedural issue to go over first. We've discussed that and whether or not these are two separate corporations, whether or not does it survive the 2005 stipulation. If it does, you're in a different position. If it doesn't, you're not.
Well, yes.
What I'm trying to tell you is we have your argument.
I mean, that has survived very clearly. When Judge Hester gives his decision in January 2016, 2014, there's a case before him to vacate the stipulation.
Sir, you have 1 minute left.
Mr. Fricola is speaking. The court. Mr. Fricola, let me interrupt you for a moment. Judge Hester's order was in two cases. One, Playtime Boutique, Inc. That was the plaintiff and Phyllis Fricola. The second was Playtime Boutique versus Phyllis Fricola individually and the sole shareholder of Hydrenia, Inc. That order is not for First Choice Realty. Accordingly to the record in this case, those two cases were the subject. That was the action that resulted in Judge Grove's ruling, which is the sole order. You have brought a case today, a different caption, and you want the court to do something about that other action. That other action is First Choice Realty. You can't do that. This isn't part of the Playtime Boutique. I'm not sure I understand how you can do that. Well, for 6 years, we've been arguing that this sole order puts First Choice Realty into that stipulation. Mr. Fricola is confused. Well, there is an action. There was an action, index number. I think it was 2000. 200997.
Your time's up. The reason we have records is we read them before you get here. We've read the testimony. We've read the argument. I've outlined for you what we think the procedural posture should be, or is probably going to be, and we're going to resolve that issue. But your time is up now. We have it. We have your argument. We understand what you're arguing. That's all I can tell you at this point.
Judge, what I could say to you, Your Honor, is that when this corporation was dissolved by the state of New York, it had to proceed to wind up its affairs. It's been interfered with to wind up its business affairs.
And that's what you argued in your brief, correct?
Yes.
Okay, and I'm saying to you, we understand that. It's not to go past
I don't
our
understand
question.
what else you're looking for then.
What we're looking for is we're looking to hear from your other side.
I have the deeds that are fraudulent.
Well, I'll tell you what we're looking for.
We agree with that.
We're going to give you a decision, whether you right or wrong. We're going to be giving you a decision. We've looked at the paperwork. We've looked at the deeds. We've looked at the transcripts down below. We've looked at the history of the case. We are where we are, and it's a procedural issue as far as I'm concerned. We'll look at it. If it overcomes it, it's a different story. So we have your argument, and your time is up. Thank you for coming.
Okay, I would just like to say one more minute. There's 9 years of tax returns, Your Honor, that have to be completed, filed with the Internal Revenue Service, the money paid for the taxes, and we're being hindered and delayed.
Okay.
And not being able to file these taxes, and it's just an unjust situation here.
Thank you. Good morning.
Good morning, may it please the court. I'll be very brief and rely on my brief unless the court has any questions. Even if there was some theory that Mr. Fricola is bringing this action in some other capacity, the only involvement by Getnick, Livingston, Atkinson, and Priori was the preparation and filing of the two property transfer deeds in June and August of 2006, respectively. This action was filed in June of 2017. So the statute of limitations for any alleged wrongdoing in connection with those transfers had long since expired. In addition, it's undisputed that the firm was relying on the so-ordered court-approved stipulation, which
From
expressly
2005.
authorized. That's correct. Thank you.
That's it, sir. Thank you.
Your Honor, I would just like to say one more thing.
Excuse me, sir. Sir, excuse me. We don't allow rebuttal in the appellate division. You're representing yourself. You have to comply with our rules. Okay? Thank you.
1443, De Niro versus Aspen Athletic Club. Justice Presiding Center is recused on this case. I beg your pardon?
Kevin Van Duzer for Aspen. May it please the court. We're seeking reversal of the lower court's order, which denied summary judgment. I submit that summary judgment is warranted in this case.
There were two AEDs.
Yes.
Neither one was operable. And you think there is no question of material fact as to your client's negligence as a matter of law?
Yes, I do. I think there's, if I can answer, 3 bright line rules, clear rules, expressly stated by the Court of Appeals cases that I cited. The first rule, there can be no cause of action against a health club for ordinary negligence with respect to AEDs, whether the AED is operational, not operational, whether a health club uses the AED, whether it doesn't, whether the battery's dead, whether the battery's not installed, or
as long as we have one that looks like one, you're okay.
No, that's not. I'm not okay. Maglino made clear that 627A, general business law, the only way we get to AEDs is through this statute. They say that 627A was designed to protect. It was designed to protect health clubs and their employees from the risk of liability for ordinary negligence with respect to AEDs. How can there be a finding?
But the statute only,
sure.
The statute, the general business law, which incorporates the public health law, doesn't exonerate health clubs from liability entirely for negligence.
From negligence?
Just from negligence entirely.
Right, there's still the duty to...
It doesn't say you may not bring a cause of action in negligence against a health club.
Correct. But the duty is only to administer CPR and call 911. With respect to AEDs...
Well, the duty is also to have operational AEDs on site and a person who knows how to use them.
That duty is, as clearly stated by the Court of Appeals, does not create a cause of action. That duty does not create a civil cause of action from the health club to the patron.
Would you agree that the Aspen violated general business law section 627A? Would you agree with that?
We can assume that they did. I'll
assume that they did. Well, does it require an operational AED? Or can you just have a broken one there and be compliant?
Whether it does or it doesn't, and we'll assume that it does. We'll assume that it requires an operational AED.
Right.
It requires, for example, you can access it. It requires a battery and operate. Assume all of that.
Okay.
It will not create a duty running from the health club to the patron. And it will not create a cause of action for ordinary negligence. The only liability with respect to AEDs comes from if you use it, and if you use it in a grossly negligent manner. That's clearly what those cases say.
Who's the statute designed to protect? Health clubs or the health club users?
It's designed, the class of person, class of risk, we can assume that the plaintiff falls within that category. I'm telling you, assume that. But the Court of Appeals has made clear unless the legislature said this is going to create a cause of action, a private cause of action for negligence, we're not going to find one. We're not going to find one. So yes, statutes in general, if it's a class of risk, class of person scenario, generally you can use the statute for a cause of action for negligence. Here, the Court of Appeals has said there is going to be no duty, there's going to be no cause of action for ordinary negligence, okay, running from the health club to the patron. The only thing that this statute can be used for, the only way it can expand the limited duty is if it's used, and if it's used in a grossly negligent manner. That's what the cases say.
So there is no duty to have an operational device?
There's no duty to use it.
Understood.
So,
but
yeah.
is there a duty to have one on premises? So that it
There's
could
an
be
obligation, when we say duty, okay, yes, there's an obligation to have it, there's an obligation to comply. But what the Maglino case specifically says is that that duty, there's not going to be a private cause of action running from the health club to the patrons, okay? And that statute, 627A, actually protects the health club for causes of action for ordinary negligence.
If you make a judgment not to use it, you're protected, correct?
Right, yes.
But other than that, if you violate the statute, isn't that per se negligence?
Absolutely not in this case. Not in this. I understand the argument. I mean, this is bar exam stuff, the class of person, class of risk. But Maglino has specifically said that's not happening here. That's what they say. We're not following that.
Well, they said that there's no cause of action for failure to use one.
Right.
We don't have a failure to use one here. We have a failure to have an operational one here.
Correct, we do.
So,
but that is not going to create a duty, a cause of action running from the health club to the patron. That's what the case says.
So if they had no AED devices at all, there would be a cause of action, right?
I don't think so. I don't think so. I think what the cases say, I've read them a million, you know, up and down and sideways. I think there's 3 rules that come out of those cases. 1, there cannot be a cause of action for ordinary negligence, period. The second one is that there can be no liability if the AED is not used. I mean, the case says it does not create a duty running from the health club to its members to use an AED. It does not impose liability for usage failures. That has to be given meaning. Well, the legislature did not intend to impose liability for usage failures. Sure.
The facts here are, there was one that didn't work at all. There was one that was in a box that was never taken out and a battery put in. Right. So we're not talking about a decision not to use. There was nothing that was operational, correct?
It's not about a decision, it's whether they used it or not. It was a usage failure. They failed to use it, they didn't use it.
They couldn't use it.
Right.
They couldn't use it because there was nothing that was operational.
Right, and that is not...
And you're saying that that protects them.
I'm not saying that. Maglino is clearly saying that the legislature did not intend to impose liability on clubs for usage failures. And I think
this was, right, and I agree with that. This is not a usage failure. You know, when they talk about usage failure, it seems that they're talking about like manufacturing defects. Like they're not going to impose liability on clubs for manufacturing defects or problems with the product itself. But this is not that. This is the failure to have an operational product at all. And so the facts are different. It seems to me your argument really is more a proximate cause argument.
I think if you, maybe not, if you read DiGiulio and Maglino together, I think it's clear what I'm saying is correct. In DiGiulio, the employee didn't know how to open the case, the glass case to get the AED out. He didn't know where the key was. Okay, he didn't know it was unlocked. That's why he didn't use it in DiGiulio. And what we get from DiGiulio is the Court of Appeals in that case did not do an analysis of whether there was a cause of action for negligence. They didn't do that because there can be no cause of action for negligence with respect to AEDs. That's why they didn't do it. The other thing we get from DiGiulio is that they assumed there was a duty to use it.
Let me just backtrack you for a second. When you say there can be no cause of action for negligence for
With respect to
AEDs.
Right.
The statute says for the use of AEDs. You don't see that as being different than for AEDs.
Maglino actually says
That's
with
really the
respect
question
to
in this
AEDs.
case.
Right. Maglino, and it's not me, I believe clearly says with respect to AEDs, there can be no cause of action for ordinary negligence.
Right,
It
so
has to
what's
be used and it
under,
can only be.
Under your
Yeah.
interpretation of section 627A, it affords zero protection to any health club members. I can't imagine any scenario
I
under your
disagree.
analysis.
I disagree.
How would any, under what circumstances would there be a duty or negligence to somebody who has a heart attack in a health club under the statute, under your view?
The duty that has existed for decades survives, the duty to call 911 and administer CPR.
But
That's always there.
But no duty under the statute.
The duty, no, that's what Maglino says, there's no duty running from the health club to the patron unless they use it and they use it in a grossly negligent manner.
What's
That's
the
what
purpose
the
of the
case says.
statute? Why even have it then?
And that's explained in the Maglino case, to encourage them to have it and use it, and they're protected though unless they use it in a grossly negligent manner.
Okay.
This is the dissenting opinion.
But if we accept your interpretation of Maglino in the statute, there's also no consequence for their failure to have an operational AED on site.
Well, there may be a consequence, there may be a civil penalty or fine, whatever the statute or governing body imposes as a sanction, but the case says, without question, that this statute is not going to create a duty, a cause of action for a plaintiff or a patron against health.
If you lose on that issue, I read your brief the same as Justice Peredato apparently did, in that your brief seems to be going in the direction of, even if there was an operational AED there, it wouldn't have made any difference because you had a doctor on site performing CPR, you had another person who was helping, the EMTs arrived within 5 minutes, they had their own AED, and so it wouldn't have made a difference, it wasn't the cause of his death. Are you arguing that at all on this appeal, or are you just relying on
I'm
your
not
duty?
arguing that. That would be a trial argument. I suspect that's the reason for the Maglino rule, that, you know, the most that we can do is call 911 and administer CPR. We're not going to tag a health club with liability when it comes to these AEDs. I suspect that's the rationale for the rule that I'm telling you that I think Maglino says.
Thank you.
Good morning, may it please the court, I'm Eric Ward. So my client is Z. Z Medical is a supplier, as you know, and Z Medical under contract.
It's really an Espinal analysis, correct?
It's an Espinal analysis, Judge. That's exactly what this comes down to. And in our view...
What's the argument about launching an instrument of harm with respect to your client?
I'm glad you asked that. Launch, all right? In fact, in the Church case, which is Court of Appeals case cited in our brief, the court recognized that launch is an action verb. You have to do something. And here, and it's also established early on by the Court of Appeals, back to Judge Cardozo in the Moak case, which was supplying water to the city and not having enough pressure in a fire hydrant, so a neighboring building burned down. All right, that was a failure to act under the contract. And in our circumstance, we have a failure, a claimed failure to set it up. So I think under very strong Court of Appeals precedent, there is no launching of an instrumentality of harm.
Your client's alleged negligence just maintained that it didn't make anything more dangerous. It didn't make things worse for the person who died. It was status quo, and that's not launching anything.
That's correct. So, and that's what our argument is, Your Honor. And it's a situation that's exactly what happened here. When Z sold the Zoll AED to Aspen, there was a non-functional AED in the building. All right. After Z sold the AED to Aspen, that didn't change. There was still no functional AED in the building. Now, because it was sitting in its box in a room at Aspen.
Right. Their only shred of hope is on their argument about Amy Peters, the sales rep, allegedly said, "I'll come set it up for you," and that seems to be what they're trying to...
That's an interesting point, Judge, because I don't actually think that changes the analysis, and here's the reason, okay? Under our interpretation of what went on here, contractually, Z had no duty to set that up. So not only did it not have a duty to the decedent, it didn't have a duty to Aspen to do anything. But even if you take
They
that...
charge an extra fee for that, correct?
And never got, yes, and they charge an extra fee, didn't bill it, never got paid it, because it was never ordered. And in fact, that's, if you want to dig down to the details, that's the difference between Aspen ordering the Vital Line Premium AED service versus the Vital Line Premium Plus service.
They got the premium but never registered for it.
And they got the premium, but the plus is the one that says, hey, we'll set it up. They got the premium, and they never set it up with the Z contractor, who the purpose of that was to notify the health club when, like, batteries might be getting low, you know, those sorts of things.
So there's no setup obligation in the premium.
Correct. That's our view. Okay, now let's take the Peters testimony, in which she, there's testimony that she had set up an AED in a previous Aspen facility. Okay, I think actually in 2. At best, that's a custom and practice. Okay, so at best, that is a contractual. Let's say now that there is a contractual duty to set it up by the virtue of that discussion. I don't think that's the case, but let's just assume for a moment that it is. It doesn't change the analysis because we still have Aspen and Z being contracting parties, and the question is whether, as a contracting party, Aspen owes a duty of care to the decedent, which, back to your point, is the Espinal analysis. Excuse me.
As far as setting up just technically, it's just putting the batteries and plugging it in, right?
It's getting it out of the box and putting 10 batteries in it that are shipped separately because they're lithium batteries and you can't put them all together. And it's just sticking them in. These AEDs, and I think there's some pictures of them in the record, but the AEDs are very simple devices, and in fact, they tell the user exactly what to do, how to operate them. So it's not a very tricky sort of thing that you get a lot of, that there's a lot of technical expertise that has to go into it.
The only problem was the batteries weren't in. Otherwise, it's perfectly operational.
That's exactly right. That's exactly right. And what happened here, of course, is that it got drop shipped from the Z warehouse to the club. The club gets it, and they don't do anything with it.
Puts it in the back room.
They put it in the back room. All right. I think, you know, there are, under the Espinal analysis, Judge Curran, there's also, as you know, a couple of other factors. One is whether...
I don't really see those being seriously argued by the other side.
I don't really think so. The only thing that the plaintiff does argue is that this case justifies the imposition of sort of a new duty.
Public policy.
Yeah, on a public policy. And I would argue, and have argued, that...
We still have to get past the Espinal.
Yeah,
Right.
You're right, Judge Peridotto. And even if you were to do that, in this particular case, I think that would be a very, I won't say dangerous, but a finding with great implication. Because if Z has a duty here, then every supplier of an AED under contract has a duty to every patron of a club. That is expanding the liability exponentially. And if an AED supplier, why not a fire extinguisher supplier? Why not a smoke detector supplier? Why not a cell phone supplier?
So plaintiff seems to argue that Langdon creates another Espinal exception. That Langdon, you get Langdon plus Espinal. You're saying public policy from Langdon is a consideration in applying Espinal factors. They seem to look at it differently.
Well, I think I think it is an Espinal factor. But even if you were to look at it differently, and even if we were to gaze only at public policy for this case and make a determination, ignore Espinal and just say, hey, is it a good idea under public policy? I think the answer to that even is no. For the reasons I just said. Otherwise, every supplier of every piece of equipment to anyone is subject to a duty to the general public. And that would just turn all of the Court of Appeals case law on its head.
If I don't put the batteries in for my smoke detector at home, perhaps the company who sold it to me has got a duty and...
Right. Or if your cell phone doesn't work because you can't call 911. Is the cell phone manufacturer or Verizon or whoever, are they liable? I mean, it just would go on and on and on. And I think to me, that's a fairly kind of obvious issue there. So unless there's any other questions, I will sit down.
Thank you.
Thank you.
Good morning, Your Honors. May it please the Court. I represent NPRO, and I would respectfully submit that, my client's even further removed than Z. By way of quick refresher, we
You got an agreement with Z to administer the...
Completely. Just far removed. The implications, the smoke detector argument that Z made, it was the same one laid out in our brief. There is no duty that has been recognized. But I would even, just to talk about what NPRO does, again, it provides online software services for the user to use. In this case, 4 emails were sent, 4 voicemails were sent, trying to reach Aspen, and they did not set up the service. But even if they did set up the service, there is nothing in the record whatsoever, by contract, deposition testimony, or otherwise, and plaintiff would agree, that had any obligation upon NPRO to set up the AED,
There's simply
install.
no duty.
There's no duty.
You're
right.
even more remote than...
More remote than Z, more remote than Z, I would submit. But
Right, and
just to be clear, there's no evidence that we had any obligation to install, set up, maintain the AED. We don't manufacture the AED. We just provide the online services so that an end user could, follow federal, local, and state guidelines with respect to AED usage.
Right, what the trial court, I think the two arguments both of you make is that duty is an issue of law. The court here denied the motions on finding factual issues, which is completely irrelevant to the duty issue. The court's got to say up or down on that.
Correct.
So you don't go to trial with the jury determining duty.
Correct.
And that's where the error was here for both of you.
Correct. And a review of the order does not delineate the duty itself. It just says there's issues of fact. And I can find no duty in the state, in the case law or the statutes.
Thank you.
Good morning, Your Honors.
Good morning.
I'm John Sharundalo, and I represent the estate of Ron Peligro, Mrs. Peligro, and the children. And I guess with regard to Aspen, because they started this, we read Maglino quite differently than counsel does. I believe that there is an obligation for a health club to have a usable AED. It's made by the statute.
They actually kind of agreed with that statement. They say, let's assume that the statute does require that it has to be operational. Fair assumption.
Yeah, and clearly this was not. And clearly it was not operational because it was never set up. Whether that's their fault or whether it's Z's fault, I guess we'll find out. But the bottom line here is that they did not have an operational.
What is Z's doing?
Z is the seller. We have 9 claims against Z. This is one motion that they're making against one claim. Z is the seller of a product that, under product liability terms, has a obligation to be sure that the product is reasonably safe for use, that it's...
There's no claim that the product was inoperable, simply the battery wasn't put in it.
That made it inoperable.
I'm sorry?
The product as delivered was inoperable.
So it should have come with batteries in it?
Well, it should have come set up. Like when you buy a car, you go to the dealer,
So it's Z's duty to come into the club to set it up?
Well, it's
they
like...
owe their duty to the decedent?
Absolutely. It's like buying a car. If you go to buy a car and there's a recall on that car and the dealer says to you, I'll take care of it, and they don't, and the recall goes out and you kill somebody with the car, that third party that you kill has a right, a cause of action. This is no different than that. I know that we're looking at Z in the context of solely a contractor here. Z sold a product here. And part of the sale of the product, and they admit this in their answer at page 102 of the record, is that they offered to set it up. They never did set it up. There's a question about whether Amy Peters made calls or not, and there's no record of Amy Peters making any calls from her phone or any of the phones that she used while she was working for Z. There's no indication that she at all tried to set it up. There was an obligation and a contract that Z would set this up. Now, was the contract in writing? Well, maybe it was based on past practices or not. Clearly it was. Clearly Amy Peters said she would set it up. They have admitted that she has said that she offered to set it up. And she never got to the place of business to set it up. Why? I don't know. She says I called. They said she didn't call. There was never any impetus by anybody to get it set up. But the bottom line is Z is not only a contractor on a service contract, they are a provider of a piece of equipment that is deemed to be merchantable quality, fit for the purpose intended, or
So you're
otherwise
saying this is a
foreseeable.
products liability action?
There is a product liability action. 8 of the claims against Z are product liability actions. This is one motion against one negligence claim against Z.
So you've alleged either a manufacturing and/or a defective design defect.
Exactly.
And those will survive regardless of what we do.
That the product was not reasonably safe when it was delivered. And it wasn't reasonably safe because it didn't have batteries in it. And it didn't have batteries in it because Amy Peters had an obligation based on her agreement with with the owner of Aspen that she would put them in. She says she called to try to get them put in. I don't know what that means because over 3 months, it would seem to me that you'd be able to find a time that you'd be able to. NPro takes over Z's obligation under a contract, and I know that this goes to the next step now. Now the product's delivered. The product's not reasonably safe because it doesn't work, because you can't operate the product because it doesn't have the batteries in it. So now we're into the next stage. All right, now there's a contract that Z makes, which is the Z premium value, whatever. They now make a deal to sell those contracts to NPro. NPro now has 188 contracts which came in the first quarter of that year that they can't even sign up because they send emails from NPro who nobody's ever heard of. I mean, Mr. Polis never heard of NPro. He may be getting emails all the time from NPro, but I'm sure he's looking at them saying, who are they? And just dumping them. Phone calls from somebody from NPro who's trying to sell them some kind of...
So the emails, phone calls, none of that would be sufficient on their part?
Well,
even if they have
it's like, I mean, when I get emails from people all the time, and I get emails from people that are selling me services all the time, and I don't even look at them. I don't even read them. I mean, if Mr. Zolos gets an email from some company named NPro saying, I want to manage your AED program, he's not going to do that because he's already got Z. And Z never tells him that NPro is going to take over.
Well,
But didn't he purchase that premium line?
He purchased the premium line from Z.
So,
but Z...
he already bought it. People aren't trying to sell him stuff. He already bought it, and they're trying to follow up on it.
No, well, the trouble is that they're trying
NPro
to follow up as NPro, not as Z. And it's not the Z value line premium, it's the NPro super duper deal that is better than the value line premium. I mean, so it's like looking at two oranges and apples. I mean, they can say all they want, well, we sent emails. Well, we've never seen the emails, number one. But number two, the emails come from NPro, and they talk about a premium benefit that is different from the NPro, or different from the Z benefit. It's a different name. It's a total different name. It's not, and if somebody were to get those emails, they would just think they're somebody trying to sell them something, waiting to hear from Z. And he never hears from Z, because Z never comes to set it up. Z never tells them that they're going to sign the contract to NPro. The first time that Mr. Polos ever heard of NPro was in the deposition that we had of him. He had no idea who they were. He had no idea that they offered any kind of service, had no idea for sure that they took over the contract that he paid to Z so that they would make sure that the machine was operational.
All of this sounds like possible breaches of obligations between Z and NPro, but I'm struggling to see where NPro's duty to your client.
Well, the fact is...
okay, go ahead.
The fact is that there was a device that was put into play that was not reasonably safe. Wasn't reasonably safe.
But NPRO didn't put it in, but NPRO
No,
didn't do that.
No, but the claim is that it's not reasonably safe. Clearly, it's not reasonably safe because it doesn't work.
Right.
They try to get it to work when Mr. Peligro goes down, but it does not work. So they try to get it to work. It doesn't work. So the product is not reasonably safe for its intended use or unintended yet foreseeable use. So the product is out there. So now, is that a dangerous instrumentality that requires something to be done about it? And that's where we say that MPRO comes into this, because under Espinal, if you have a dangerous instrumentality, you have to do something about it. You just can't walk away and say, I have no obligation to some third party who's going to be injured by that defective product. I have no obligation to that injured party, so I don't have to do anything about it. MPRO's holding the bag here. MPRO's got the contract. They got to do something about it. We have a device that doesn't work, and it doesn't work because it wasn't set up right. And MPRO's obligation is to, once it gets set up, is to take it over from there. But MPRO gets in, and all of a sudden, they don't even check to see what the status of it is. They make emails and phone calls to somebody that they don't never heard of.
When they never hear from them, they do nothing.
Yeah,
You say they
and they
should
don't
do
hear
more.
from them, so they just walk away and do nothing. And for 3 months, the machine sits there with nothing being done on it. Polos believes that it was set up because that was his understanding with Amy Peters. Amy Peters never sets it up. And
Do you agree factually that setting it up means just putting the batteries in?
no, I think there's more to it than that, because not only is it setting it up, put the batteries in, you got to form the arrangements with the local 911 entities to register the device. And you need to get the machine up and running so that you know it's running accurately. You got to have the pads for it, which they didn't have. You got to have all the appropriate devices that go with it, including the wires and the pads. And there's no indication they had either one of those, because the day after this, they ordered pads. And so there's more than to setting it up other than just putting batteries in it. I mean, these AEDs in health clubs and places of public accommodation are under a guise of the legislature, where they need to be registered, they need to be monitored, and they need to be monitored by the local health facilities so that they know that they're certified and working. And in this particular case, it was never registered, it was never certified, it never worked. A product was delivered that was not reasonably safe because it didn't work, it needed to be finished, and the product wasn't finished. It's like somebody who says, I'm going to sell you a car, but you don't have good tires on it, I'll get you the good tires, and he never gets them. You use the truck and it go out and have a blowout and you kill somebody. That is the scenario that we have here. Just because we're talking about a contract with Z and a contract with MPRO, we have a product that's out there that's not reasonably safe because it doesn't work, and a product that will do damage unless something happens to it. And MPRO had an obligation to do something about that, because the first prelude of Espinal says if it's a dangerous product that is going to do harm, you need to do something about it, and you have a direct relationship then, or a direct duty to the customer that's using it. In this particular case, this is a product under product liability law, Codling versus Paglia. Anybody who's injured by a defective product can bring an action against the manufacturer, contract or no contract. So Z is in this case under a product liability claim and under a negligence claim of product liability. And in addition to that, Z is in this case because they agreed that they would set it up. They didn't set it up. They didn't get it working, and it wasn't working at the time that Mr. Peligro went down. And I think that succinctly gives my argument.
Thank you.
Thank you for listening.
1444 and 1445, Carr Hoagland versus Patterson.
Good now afternoon.
Good afternoon, Counsel.
Tim O'Connell for Ms. Carr Hoagland in both an appellant and a respondent capacity. These issues, the two issues before us today, are both medical, one dealing with the defendant and one dealing with the plaintiff. Dealing with the defendant's issue, and I want the court to appreciate, I put it in my brief, I am not without empathy to someone who is suffering from dementia or Alzheimer's. I've got them in my own family. I've got personal friends. I am with great empathy.
But you have an obligation to your client.
But I have an obligation to my client. And I would not permit those persons to be operating an automobile, and that becomes the crux of this actual case. What's behind it is when you suffer from dementia, and advanced dementia, like this gentleman was diagnosed with, you are easily confused. You don't properly perceive things. You have extreme medical issues. And the 6 medications that this gentleman was on at the time of this crash, they add to it.
Let's just stop right there.
Go ahead.
We look at it as 2 issues. We have one issue dealing with the pharmaceutical.
Correct.
Okay, and we have one issue dealing with the doctor-patient.
Correct.
Okay, we have 2 separate. It appears to me, how did he place in the controversy? How did he place in controversy? Forget the prescription for now. His medical condition, when he seems to have provided those documents as to a reason why he could not be deposed, which was a long time after the accident.
Well, there's actually 2 issues, and if I may. The first is the Petrovitz decision of this court, which says, okay, plaintiff, you get the facts and incidents. Okay, we've been asking for the facts and incidents, we still don't have that. Okay, now going to your issue, the question becomes then, and I leave it to this court to decide because it's an issue that I struggled with, but counsel acting on behalf of the defendant who was then living opened the door and voluntarily inserted into the litigation.
But he gave a reason why the defendant wasn't available for a deposition as to the medical. He didn't offer it as a defense as to why.
Agreed. Agreed. However.
So how does he put it into controversy?
Well, first of all, the medical records as disclosed were 1 year post-crash, which indicate that it was ongoing treatment. There were 2 other neurologists that treated him first for severe dementia, a lot of significant issues that he was dealing with. And the question really becomes, should this gentleman have been behind the wheel to begin with?
Right, so, and I don't disagree that it would be relevant. His mental condition at the time of the action is relevant. But we're talking about our privilege here.
Correct.
And no matter how relevant something is, that doesn't get beyond this privilege. The only way to get beyond it is if the defendant, as Justice Troutman said, puts his medical condition at issue, like raises it as a reason for why he did what he did, or somehow as a defense. So yes, it's clearly relevant. Did he have dementia at the time of the accident? But I'm not sure that is the question.
Well, that's why I made the distinction, Your Honor, because the facts and incidents, we believe we get that. But directly to your issue that you just spoke of is we simply say that it was waived. It was waived.
It was waived because his lawyer said he couldn't be deposed because he has dementia.
Well, it's a little bit more involved than that. That was not disclosed until September of 15, after we had already requested numerous times deposition, no response was provided, got an order of the trial judge saying you will be deposed, no show, went back in on another motion saying, okay, now order it, put teeth in it, or strike the answer. And it was only at that time in September of 15 that we finally had this, he can't be deposed because of severe dementia.
Let me ask a fundamental question.
Go ahead.
You say that the reason you want these records is because he shouldn't have been behind the wheel of the car at all because of his medical condition.
It's an issue I believe that needs to be explored in discovery, correct.
Okay. It doesn't matter whether if he's unless he operates the vehicle in some sort of negligent manner, it doesn't matter. You know, I mean, we've got cases where someone's, you know, completely intoxicated, but they're stopped at a stop sign and they don't do anything wrong. They don't do anything negligently. So I guess I'm trying to see. I'm struggling a little bit with the relevance if we get past the privilege.
Judge Troutman issued a decision years ago that I've used on DWI cases. Okay, the sheer fact that you have a DWI, you're right, it doesn't come in. There has to be more.
Has to be negligent conduct.
There has to be more, or a recidivist.
Or a
and
what?
A recidivist. Someone who commits the same act over again, okay? There's a pattern. And what we're saying here is based upon the records that there is a pattern that the gentleman was severely suffering from numerous maladies, including severe dementia, before the disclosed records indicating that there was continuing treatment.
But to Justice Paradow's question, there was a witness that suggests it wasn't necessarily the defendant's fault of the accident.
Correct. However, and what I pointed out in his testimony, first of all, he indicated that he spoke to the gentleman and he was bewildered. That was the word he used. Secondly, this gentleman also admitted that he's coming up to the circle. He's at least 45 feet behind the defendant, and he is looking to the left, looking for oncoming traffic. And when he turns his attention to the right, he sees what he admits in my questioning of him to be more than likely an ongoing event.
But that's all an issue for trial, right?
Correct.
Mr.
Absolutely correct.
Your point, if I understand it correctly, is that this is discovery. You don't know what's going to happen at trial. For all you know, the defense could stand up and say, well, you should excuse the defendant's behavior because of X, Y, Z.
Exactly.
Right? But what I'm stuck on is the Dillenbeck analysis. You know, the Court of Appeals case that lays this out. And at first, we have to find whether or not it's in controversy, and then under Dillenbeck, whether it was waived. So what I'm stuck on is whether it's really in controversy. What act did the defendant undertake here on this record that affirmatively placed the defendant's medical condition at issue in controversy in this case?
There's no question there's hair splitting there. I understand exactly where you're going. What I'm saying is that by the sheer fact of the medical records that were voluntarily submitted very belatedly, in my opinion, on excuse for why he couldn't be produced, that also is going to be used at the time of trial to excuse his conduct.
What indication do you have of that in this record?
I have none.
So there's no basis in this record to find that the defendant has affirmatively placed his medical condition at issue or in controversy in this case?
For the happening of the crash, absolutely right. However, belatedly, my position is, and I have to take it, is that that issue was inserted voluntarily. There's a waiver. Now we not only get the facts and incidents, medical data predating the crash, but we should also get access to...
You see my hiccup in that
analysis. No question. There's no question. I saw the hiccup.
And then waiver.
Oh, I'm coming here well aware of that hiccup. And that issue, okay? I'm here saying, all right, you are faced with a very difficult decision because there's so few decisions on this issue in the case law. I understand that I'm actually asking you maybe to take a step a little bit further, but based on these facts and these facts alone, limited to this case, not opening or expanding the policy and procedure that you've previously issued. Would you like me to address issue number 2 or wait for defense?
No, the bifurcation.
Very good. Bifurcation.
You think the court did the right thing?
Oh, there's no question. Because here we have, again, the testimony. If you take, we actually submitted to the court 3 separate issues. Testimony, the bill of particulars, and if you really take a look at the medical records, the ambulance report at 285 says it all. The discussion says plaintiff, or the injured person says the defendant struck her in the left leg. There was immediate pain, then she fell from her bike. That is completely consistent with her testimony. I had significant pain upon significant impact with my left leg, my left side. Defense is contesting liability, saying no, she came from the right.
Right, how the accident happened, where she got hit from behind or she ran into him, the medical evidence you think is going to support your client based on how she got hit, and therefore they should be tried together.
Absolutely, and especially when you couple that with the physical evidence of the dent to the rear wheel, there's no question that it is absolutely significantly intertwined with the liability issue and must be tried together. Thank you.
Good afternoon.
Good afternoon, Rachel Eminger for John Patterson. May it please the court.
Is there a difference between medical records and pharmacy records? In other words, does privilege in CPR, do they list pharmacy records?
Based on my review of the case, that I would say that there is a difference between the, at least based on what the case law says, the difference between the pharmacy records and the treatment records. In this case, the plaintiff is asking for some pharmacy records and then some treatment records. And I think what Your Honor is referring to is the facts and incidents. And what he's saying is that I don't need to show that there was a waiver of privilege for the facts and incidents. But what does need to be, still needs to be shown, irrespective of the waiver, is that it's material and necessary to this action. And I think
is it
the
in
court,
controversy? In
controversy, yes. And that would be, for that, just the standard discovery analysis.
What
and
affirmative act did the defendant get into in this case with respect to an affirmative duty or affirmative invocation of this condition as an explanation for the accident? Anything?
No, and it's our position there.
Question, but I did the best I could.
It was a wonderful question, and it lends to our position, so I think it's fabulous.
You may be the only one that thinks so, besides the judge.
This judge thinks really great.
I think you're doing great.
Thank you, Ms. Evanger. You get the
yeah, that's it for me. But no, I say that there is absolutely nothing in the record that affirmatively puts it in controversy, and I think that Dylan Beck very explicitly says what the standard is. It affirmatively needs to be placed as a counterclaim or to as a reason to excuse some conduct. And now my opponent says, well, what if we get to trial or someplace down the line? Well, if that's the case, there's going to be an amendment of the complaint, and there's going to be other discovery when we get there. But at this point on this record,
this is my problem with the issue, though. Trial's too late. That is, you're there at trial, and all of a sudden you start putting in an argument in the opening that says, well, look at the condition of my poor client. His negligence, if any, should be excused for whatever reason based on his medical condition. There it's too late. Where's the line here in terms of, geez, when do you have to say, I'm not going to invoke it?
Well, I think it's, I understand your question, but I think that that's really the analysis of any case of how it evolves and how things change and amendments and that sort of thing. So to say here today, I don't know what that trial judge is going to do. I don't know if we tried to raise it at trial that it would even be permitted at that point. But on the record before us, it has not been affirmatively waived. I'm
sorry to interrupt you again, but one practical point, this is my final thought, one practical point, I suppose a letter to Mr. O'Connell saying we're not going to do that? Or is it too soon to do that?
That could be an option, yes.
And if it's too soon, that would underscore his point, is the only thing I'm saying. That's my point.
Yeah, and I do understand, but I think before you today that, you know, if some letter to the extent that we wouldn't need to do a letter because we have our answer. There's been no counterclaim. There's been no affirmative defense of it.
You're good.
Why don't you address the bifurcation?
Sure. And I did want to address one last point on the in controversy, and I would just really quickly wanted to point out in terms of the medical records that were presented, just not of our own volition, but in order to defend on the deposition issue. But those start way after the accident, and actually. What was that?
We recognize it.
Okay,
I mean,
thank you, Your Honor. And then just on the bifurcation real quick, I just wanted to note that the standard with respect to bifurcation, that it has to have a significant bearing on liability, that the nature of the injuries have to have a significant bearing. And I think on the record before you, I think that there's only been real suggestion or speculation as to how the injury affects liability, and that's mainly in the context of the fact that the plaintiff claims that this was a rear-end accident. So there's been no showing how the nature of the injuries established that her claim that it's a rear-end accident. So I just asked you to keep that in mind.
In the hip, and that shows the rear end. If she, rather than hitting the car with her bike, she got hit in the back. That supports her.
But I don't think that she